May I, Lordship. Lordship, I would like to mention today item number 1 on behalf of D. Chaudhary. Item number 1, Lordship. Lordship, he wants the matter to be fixed on Thursday because he's from Guwahati based advocate, Lordship. Item number
On
1
Thursday next.
on this coming Thursday, Lord.
This is a DB matter, na?
Yes, Lordship.
Who will appear?
Uh, Senior advocate D. Majumdar will appear in this matter, Lordship.
All right, on Thursday. Will be another. DB did, na? Thursday. DB.
D. will apply.
Lordship, this matter may be time pass over for timing.
May I please, madam? Here, my lord, the petitioner, my lord, is the, my lord, Comptroller and Auditor General, my lord. Comptroller and Auditor General, my lord, CAG, my lord, Itanagar, my lord, Principal CAG, Itanagar, my lord. Yes, my lord, put to challenge the order dated 17/5/2023 passed by, my lord, Central Administrative Tribunal, CAT of Guwahati Bench, my lord. Lordship will find the judge order at page 28, my lord. This is the order passed by, my lord, Central Administrative Tribunal, Guwahati Bench, my lord. And relevant paragraph, lordship, is at, my lord, page 36, my lord, paragraph 9, my lord. May I read, madam? From the above, it is clear that the Staff Selection Commission changed the education qualification required for candidature of the junior Hindi translator, senior Hindi translator, and the Hindi Pradhyapak examination 2017 based on recommendation of the committee in 2018 after examination was conducted in 2017 and the result declared. It is established principle of law that any change should have been prospective and not retrospective effect. When the change education qualification are applied retrospectively and used to negate the result of this examination already declared and to terminate the services of the candidates already selected and who have started work, it amounts to grave error and is patently bad in law. As per settled principle of law, the rules of game cannot be changed in the middle of the game and obviously not after the game is over and the result have been announced. It was no one's case, my lord, that when the education qualification has been changed after the advertisement, my lord. It was no one's case, my lord. And in the light of above, the impugn order dated 3/8/2022, it's a notice of termination issued by the, my lord, CAG, my lord, Principal Bench, my lord, for termination of the, my lord, services of the respondent, my lord, deserves to be set aside and is hereby quashed. The respondent are directed to allow the applicant to continue in the post of junior translator in the light of terms and conditions laid down in the provisional offer appointment dated 27/12/2018. She was on probation for a period of 2 years, my lord. Before completion of the provision, my lord, she was issued the notice of termination, my lord. My lord, here, my lord, the advertisement was sought for, my lord, filling up of one post of, my lord, junior Hindi translator, my lord. Lordship will find at page, my lord, 38, my lord. Page 38, my lord, Annex 2, my lord, which was issued by the State Staff Selection Commission, my lord, at serial number F, my lord. The concerned post is, my lord, serial number F, my lord. Junior translator / junior Hindi translator. This is a minor, staff selection commission is a minor examining body, my lord. And lordship, at page, lordship will find at page 43, the education qualification for the required job, my lord. Clause 7, lordship, the appropriate, my lord, provision will find at page 44, my lord. My page 44, my lord, after 5, my lord, paragraphs, my lord, sub-paragraphs, my lord, for the post of F, my lord, junior translator / junior Hindi translator in subordinate offices who have not yet adopted model RR of Department of Planning and Training for such and such. First qualification, my lord, master's degree of a recognized university in Hindi or English, with English or Hindi as a compulsory or elective subject at the degree level, my lord. Or, my lord, bachelor's degree with Hindi and English as main subjects, which includes the term compulsory and elective. Note, my lord, this is important, my lord. The candidate must ensure that they have studied English and Hindi as main subject in all the 3 years of the BA pass course, my lord. My lord, in absence of the master's degree, my lord, she or he will be eligible for the said post, having, my lord, bachelor's degree with Hindi and English, my lord, and Hindi being main subject in all the 3 years degree course, my lord. This is the requisite education qualification, my lord. And lordship, thereafter, my lord, the respondent number, my lord, private respondent, she was given the offer of appointment, lordship will find at page 49, my lord. On 27/12/2018, my lord. This is the appointment, provisional appointment letter, my lord. This was based on the recommendation made by the staff selection commission, my lord. And accordingly, my lord, she was given, my lord, provisional appointment order. And my lord, kindly see, my lord, paragraph, my lord, 4, my lord, serial number 4 of the said appointment, my lord. She will be under provision for a period of 2 years from the date of joining in the Principal Accountant General Accounts, Arunachal Pradesh, my lord. Meaning thereby, my lord, she is, my lord, appointed temporarily for a provision period of 2 years, my lord, and is under, my lord, and shall be governed by the service conditions of the, my lord, CCS rule, temporary service 1965, my lord. Thereafter, what happened, my lord? At page 22, my lord, 52, my lord. During the provision period itself, my lord, the staff selection commission, my lord, board, my lord, commission, my lord, has, my lord, written a letter to the, my lord, CNAG office, New Delhi, my lord. You will find at page 52, my lord. On 13/12/2019, my lord. Revision of results of 3 candidates, subject, my lord. Revision of results of 3 candidates of junior Hindi translator, senior Hindi translator, and Hindi pracharak, my lord, and returning of the dossiers regarding, my lord. We are concerned with the, my lord, serial number 5 of that, my lord. May I read the contents, my lord. I am directed to refer to this office letter such and such, forwarding herewith nomination and dossier of selected candidates for the post of junior Hindi translator on the basis of result of the junior Hindi translator. My lord, may I skip senior examination 2017, and to state that the commission has since revised result in the respect of the following 3 candidates, my lord. Serial number 5 is the Sujata Kumari, respondent number, private respondent, not qualified, my lord. Then, my lord, serial, my lord, at para 2, my lord, the above 3 candidates have finally declared not qualified on the basis of the revised result. In view of above, you are requested to take further necessary action at your end, my lord. And this was further clarified by the staff selection commission, my lord, why the, my lord, her, my lord, result has been revised, my lord. Lordship will find this contains at page 53, my lord, in a letter, another letter issued by the staff selection commission, my lord, to the, my lord, CNG, Delhi, my lord. May I read, my lord? Page 53, my lord.
Ready.
Revision of results of the three candidates of junior Hindi translator. We are concerned with junior Hindi translator. I am directed to refer your letter. My lord, the CAG, my lord, made some queries to the my lord, Staff Selection Commission, my lord. This was clarified, my lord. I am directed to refer your letter suggestions as dated 11/2/2020 on the above mentioned subject and to say that in the final result of the said examination declared on 14/6/2018, Sujit Kumar, roll number such and such, Sujata Kumari, the respondent, and Sri Akash Verma were declared qualified, though they did not have degree, the desired education qualification. That is, they did not study Hindi at BA level for 3 years, my lord. My lord has just seen the requisite qualification, my lord. She has to, my lord, pass, my lord, in degree, my lord, she has to pass 3 years, my lord, 3 years in Hindi, my lord. Subject matter for 3 years. This occurred due to an inadvertent error during document verification of the image nomination. Eventually, in October 2019, while processing a court case, WPC such and such at Delhi High Court, it was observed by the commission that all the above mentioned three candidates did BA in English along with Hindi as subject. However, they studied English for 3 years, part 1, part 2, part 3, but Hindi only in part 1 and part 2 of the BA examination. Hence, the result of the above three candidates were revised to disqualified by the commission on 17/11/2019 for not confirming the education qualification associated with the post, my lord. Thereafter, my lord, thereafter, my lord, termination, my lord, has been issued, my lord. Notice of termination, lordship will find at page 55, my lord. May I read, my lord? Notice of termination issued under Rule 5(1) of the CCS Temporary Service Rule 1965. In pursuance of the sub-rule 1 of Rule 5 of the Central Civil Services Temporary Service Rules 1965, I hereby give notice to Ms. Sujata Kumari, Junior Translator, that her service shall stand terminated with effect from date of expiry of period of 1 month from the date on which this notice is served on, or as the case may be tendered to her, my lord. Basically, it's a notice under, my lord, Rule 5(1), my lord, by giving 1 month's advance notice, my lord. Instead of, my lord, replying to this notice, my lord, the respondent, my lord, has rushed to the, my lord, Central Administrative Tribunal and got this impugned, my lord, order, my lord. This is no one's case that, my lord, the education qualification has been, my lord, changed after the, my lord, advertisement, my lord. In fact, my lord, she was not having that requisite qualification, my lord. She did not have 3 years, my lord, Hindi course in her BA, my lord. And in fact, my lord, in the, my lord, application, my lord, before the CAT, my lord, there is no prayer in the application, my lord, for setting aside the, my lord, revision of the result by the Staff Selection Commission, my lord. And my lord, I have my lord, they have also annexed the, my lord, degree certificate also, which is clear from the degree certificate that she has not studied Hindi in the part 1, part 2, and part 3, my lord. Only part 1 and part 2, my lord. My lord, may I pray that this statement notice may be issued, my lord. And my lord, admittedly, my lord, it's a not, my lord, not based on the, my lord, record, my lord, the order of the CAT, my lord. So this may be a state, my lord. And this may be a state, my lord, the order.
Yes, Kato.
And my lord, her service may be subject to outcome of the, my lord, writ appeal, my lord. But this has to be state, my lord.
She is still in service.
Yes, my lord, because of the order of this, my lord. CAT, my lord. He is, my lord, performer respondent, my lord.
My lord. Who is
For
the
the, my lord, no notice has been issued, my lord. This is first time. my
Regional
lord.
Director, Staff Selection Commission,
Yes, my lord.
Sujata Kumari.
Well, Union of India is basically performer respondent, my lord. The
Huh?
appropriately replied by the, my lord, the other respondents, my lord. Not by the Union of India, my lord. It is only performer respondent.
My lord,
Harshvens. It's a issue notice by this petition. Case number 24. Issue notice. Justice Service
My lord,
registered AD.
my lord.
Registered AD.
Both, my lord, because she is in the office itself, my lord. So
Registered AD. In the backgroup of text
office का नाम तो नहीं लिखा है.
and circumstances as about in the petition. And perusal of the documents. Annexed there which more particularly
इसको लगा दो.
the judgment and order. Dated
17/5/2023.
17/5/2023.
My lord.
The operation of the order dated 17/5/2023. Passed in OA number 045/00154/2020 shall remain stay till the returnable date. Till the returnable date. Let them appear.
Oh, my lord.
List. In a month of November.
November, my lord. Oh, my lord.
Map, plate, your lordship. My lord, this matter, this PIL is, this is a second round of litigation, your lordship. In fact, in this case, matter is that for the installation of a crusher machine, there is a guideline. Arunachal Pradesh stone crushers.
What are the guidelines?
Yes, I will just
Page
check.
number?
Page number is, my lord. It start from type copies in page 43. The original copy starts from
Not
page,
readable. This page is not clear.
yes, it is
No.
type copies in page 52.
52.
Yes. So I will just go to the relevant provisions. Second para, may I read first para? Numbers such and such stone crusher industry is an important industry sector in the state.
Page number and paragraph number.
Page number 52.
52.
Yes. May I read the
Hmm.
first paragraph? 52. 52 is in fact type 1. Is a type originally start from page 43.
This one.
Yes. May I read that one? The stone crusher industry is an important industrial sector in the state engaged in producing crushed stone, which is a raw material for the various construction activity like construction of roads, bridges, highway, bridges, and canals, etc. It has observed in recent days that in view of the increased demand in crushed stone for various development projects, number of the stone crusher units have come up haphazardly in almost all the districts of, and as a result of it, indiscriminate unlawful extraction minor minerals are being going on. May I take the third paragraph? Having regards to the above, Department of the Geology and Mining has decided to come up with the guidelines in consonant with the Arunachal Pradesh Minor Mineral Concession Rule 2002 to be considered while issuing NOC certificate of the department for setting up a stone crusher plant in the state. Now, the guidelines shall be called as Arunachal Pradesh Stone Crusher Guideline 2012 and shall be effective from the date of its publication in Official Gazette. This is the one. And then 1.1, it says no person shall install or run any stone crusher in any area within the state of Arunachal Pradesh without prior NOC certificate from the Department of Geology and Mining. Intended persons, form companies shall apply to no objection certificate in CU Form A to the Secretary Geology. Such application shall be submitted to the Deputy Commissioner of the district along with the following documents. So I'll just take to your lordship 1.12. 1.12, it talks about proprietors of the units shall submit a working plan cum environment management plan or duly approved by the Forest Department along with the application form for no objection certificate. So there's no issue. So another important is that it has to be installed on the basis of geo appraisal committee. That is in the 1.13. It says geo appraisal committee submitted by the geo appraisal committee at the Deputy Commissioner of the district. So the once they have submitted a plan on the basis of the geo appraisal committee, the Deputy Commissioner will approve on the basis of NOC from the various department, including the Gram Panchayat and Gamburas. So now I will just take the relevant portions. In fact, the relevant portion is that NOC has to be from DFO, NOC has to be from EAC. There is no issue here. And then the important is that I will just take the important provisions. That is, I will just take to two is the joint inspection of proposed location of crusher unit.
Who established this stone crushing factory? Where?
It is, in fact, one is a two
We
stone
did
crusher.
no objection certificate issued by this pollution department.
Yes, pollution, yes.
But your objection is there, it is creating air pollution.
No, my issue here is that there is a guidelines. I'll just take to the last guidelines. I will just do the page.
You come to the relevant points.
Yes,
okay.
relevant one. I will just come to the relevant points. Page 57. 57(6). The minimum distance criteria for the stone crusher plant from the sensitive and vulnerable places shall be as under. So 6.1, it says geo appraisal committee shall while recommending any proposal for no objection certificate for the establishment of crusher units, taking account of the following locations criteria and specify the same with reference to the following. So important one is the 6.1a. It should say that class A and above town cities limit to 3 kilometers. But the relevant here is mine is 6.1d. 6.1d. 6.1d said the wildlife sanctuary and reserve at least 5 kilometers. Whereas one of the stone crusher is within the 1 kilometer. And another is within the 2 kilometer. It means it is not complying the guidelines, which is say the 5 kilometer. That is one. Another is take to the page 58. Page 58, 6.1. 6.1e says national highway and the state road. So it says that 200 meters. But then the one of the crusher is just near to the national highway, it's just near to the bridge. That's also not fulfilling this guidelines. And then I will just take to 6.1g. 6.1g is talks about river, lake, and stream. So one of the crusher machine, RKC crusher machine, is within the small stream, which has been used for the irrigation, which has been used for the drinking water supply. And that is also within the surrounding is a orange garden. So now it is not complying this guideline 6.1g, river and stream. And when another last one is that non-compliance of is a 6.1h, that is the bridge and water supply. So one of the stone crusher is within the river, within the stream, that's called Dompu River. It's been used for the water supply. And just the crusher machine is just near to the bridge. That's called Balaji Enterprise. Another RKC is just near to the stream, within the stream. That is the, in fact, they are supposed to follow these guidelines. And then Geo Appraisal Committee also has to comply this one. But then it has not been done. So this was challenged before your lordship in first PIL, I'll just take to that PIL and after what happened. I'll just do the High Court order. This is in the 154. I'll just take to 154. An operating portion is my you'll also be in page 57. 57. Page 57. May I read last paragraph? Last paragraph. May I read the last paragraph? Direction what to the geology mining. 157. Lordship God. 157, yeah. May I read? Accordingly, we are inclined to dispose of, this was disposed in the motion stage, dispose of this PL in the stage of motion, hearing itself by directing the Secretary Geology and Mining, Government of Arunachal Pradesh, to look into the grievances of the petition or the highlights in this petition, to enable the Secretary Geology and Mining, Government of Arunachal Pradesh, to examine the grievances of the petitioner. The petitioner shall submit a representation accompanied by the copy of writ petition along with the annexes appended here to the Secretary Geology and Mining of Government of Arunachal Pradesh. So this was a direction. And then what happened is that after that, one committee was constituted. ADC was constituted as a one main committee. And one main committee report also contradicting the report of Geo Appraisal Committee. And there's two more report I want to take to that. One report was by the ranger officer. He's saying that it is within just near to the reserve forest area. It's just near in periphery of the stream. That report is there. Another report of the ADC Mebo, but the latest report is after the High Court order is done by the ADC Pasighat. So I'll just take to that ADC Pasighat report. That is may just take to the report is in
166.
158. 158. 158. This is a one-man report. 158 annexure 15. Might take to that report. Dated.
What were the observations?
Yes. His observation also not matching with the report of Geo Appraisal Committee. It doesn't match with the guidelines. It doesn't match with the report submitted by the ranger or the forest ranger, and then report of the ADC Mebo. The three reports are completely contradicting, and three reports are not complying the guidelines. That is one. I just take to the report is in page 160. 160 is the details of the distances. So I have prepared the comparatives is in the paragraph. May I just take to the paragraph. Comparative is in my petition. You also
Paragraph number.
Yes, so I will just take to that that one. Para 19, I think I will just take para 19. Para 19 is the comparative I have prepared. Now it's in para 19, but then page 27. You'll also may see page 27. So this is the parameter prepared. Page 27. Page 27 is the first is the parameters laid down in the section 6 of Arunachal Pradesh Stone Crusher Guidelines 2012, and then distance. Now there's a three report. One is by the Geo Appraisal report. Second is inquiry report. Third is the ranger officer report. Fourth is the inquiry report, latest the inquiry report of ADC. In serial number, I will just take to serial number 1. Serial number 1, it says 3 kilometers is completely blank. Now I will take to the serial number 2, page 27, my lordship. Serial number 2, it said distance from the town is 2 kilometers. It is mentioned 5, 10, 3. It's okay. There's no issue. And then important is that serial number 3 talks about the village. There's also no issue. Now the important is that wildlife. Serial number 4. Serial number 4, it says distance from the wildlife sanction reserve area. Now here it says 5 kilometers as per the guideline. But when we see this in 1 kilometer nil, in 1 second column, it is above 5 kilometers. But then important is the report of the ranger. Ranger, it says it is 2 kilometers from the Mebo Reserve Forest. This is submitted by the report of the ranger officers. It says 2 kilometers, whereas as per the guideline is a 5 kilometers. And then another, it says it's a 960 kilometers, 60 meters from the Mebo Reserve Forest. It means only 2 kilometers and 1 kilometer. That's one. And the last report, which is submitted by the ADC Pasighat, it says 5 kilometers away. Whereas the ranger, forest ranger, he says that only 2 kilometers and 960 kilometers. But then the latest report says 5 kilometers above. So it is just to make sure that the installation is under compliant. That is one. And another important, I will just take to the serial number 5. It talks about national highway. It should be 200 meters as per the guidelines. Whereas it's the all report says as per this one, your lordship, as per the rangers report, it says only 135 meter distance, whereas it should be 200, the below 200. And then the report of ADC Pasighat, it said 324, 411. And if I see this report completely not matching each other, whereas the main report of Geo Appraisal Committee, but now the 3 reports are not contradicting each other. It's not complying the guidelines. That is one. Another important, you'll also may see the river 7. Serial number 7 is very important because this has been installed within the stream of the Dampu River. 7. River, lakes, and stream. And it says that it should be at least half kilometer, it means 500 meters. Now, if I take to the report of a ranger, it says 465 meters away. Whereas if I see the picture clearly shows that the crusher machine is within the stream. That is one. Now the latest the issue here is that the report prepared by the Pasighat ADC, he himself is the chairman of Geo Appraisal Committee. As per guideline, it says that if Deputy Commissioner instructs for the Geo Appraisal Committee, then minimum committee should have minimum 4 members to inspect. Not only one person cannot do inspections. So I will just go to that guidelines. The guideline clearly says that if the inspections has to be done, then it has to be done by the Geo Appraisal Committee, and minimum they should have a 4 member. I will just do that guidelines. It is in 2.1. I'll just take back to the guidelines. Page 2.1. Page 2.1 is in. It starts from page 53. Page 53. Last 2 paragraph. It says joint inspection of a proposed location of crusher unit by Geo Appraisal Committee. Just may I read one. 2.1. It says before issuing no objection certificate from the Geology and Mining Department, there shall be eligible for the setting of a stone crushing unit by the Geo Appraisal Committee consisting with the following members. The Deputy Commissioner of the district shall issue necessary orders for joint inspection or proposed location upon requisition from the Geology and Mining Department, because there was after the direction from the Geology and Mining Department. Now it says there should be around 6 members. 6 members. It's page 54. 6 members, and then important is that below you'll also may see the note NB. It's a 1. It said the below it says at least 4 members shall have to visit the proposed sites during the joint inspection. 2. Applications shall have to arrange transportation of the members to the visit to the proposed locations. So it means the inspection report prepared by the MEBO, some Pasighat, he alone cannot do the inspection. It has to be done by the geo appraisal committee, and it should consist of 4 members. Whereas that has not been done. Only just randomly prepare a report and submit it, saying that the guidelines has been complied. This is the issue, and another important is that while installing this crusher machines, they have to comply the statutory provisions. Is in 6, is page 57. Yes, it is in 6. Yes, page 58. Oh, sorry, not 58. There is a statutory provision. It says statutory provision is 6.1. 6.1. Yes, it start from page 56.
Molay, what is the no objection certificate issued by the pollution department?
No objection certificate issued to Pollution Control Board, Your Lordship, is in page consent order is of NPBC. It's in page 93 to 97, and the one is 98 to 111. 93. This was in 2001, Your Lordship.
Hmm?
It was in 2001. Page 93, annexure 5.
Page number
93.
90. This is
Yes.
90.
93 is here. Consent order. This has been issued by the Pollution Control Board. The consent to establish operate under section 25 or 26 of Water Pollution Control Board as amended 21 of the Air Prevention Control Board 1981 refer Water Act respectively. Now this was consent in 2001, Your Lordship.
2021.
Yes. Yes, 25/9/2021.
Hmm.
Now, question is even the consent or this order auto, it has to have this has validity for 1 year. As per the guideline, it says that anything it is validity is only for 1 year. Now, in this guidelines, it also talks about the consent also should be the Gamburas. I'll just take to that the guidelines, the provisions which say that the guidelines also has to be the no NOC also has to be from the Gamburas. I'll just take to the this Gamburas NOC. Yeah, NOC may see Gamburas. I will just take the Gambura GB. Gambura का NOC
Well, Ma, we have considered the relevant documents at least today. So we will issue notice. So are you appearing here?
Yes, ma'am.
Hmm.
Let notice go, my lord.
Hmm. They have
Otherwise,
already set up their industry, is
Yes, ma'am.
continuing. There is no objection certificate from the pollution
consent
department.
by the
So
pollution
problems
control
are
board
no.
also is up to
Ultimately, expert
24.
opinion may be required, ultimately. Hmm. Some irregularities, some,
pollution control also,
Here and
it's
there,
up
there.
to 2024,
hmm,
the
okay.
certificate.
issue notice. You were representing whom?
Yes, my lord. Government, my lord.
Hmm.
Uh,
One, two. Two,
One,
can you
two.
represent?
1, 2, 4, 5, 6, 7, 8.
Hmm. So, as has accepted notice. Extra copy of the petition along with the documents as usual. Then issue notice by registered AD post to the respondents number 3. You are not
Three.
representing.
Yes, ma'am.
4 you can.
I will.
5,
3, 3, 9 and 10 by registered
Nine.
AD.
10. Notice will be.
3, 9.
Take steps within 2 days.
Obliged.
List in the month of November. First digging
Let it be after 4 weeks, madam.
after 4 weeks. After
Oh.
4 weeks.
Obliged.
My lord, it is going to be an exhaustive argument.
Hmm.
The I might take,
Have you filed your affidavit in reply?
May not require much. This is the appeal, my lord. It's a tender matter, urgency is there.
As per official affidavit in reply is not filed
Last time, although they sought for, my
by
lord, they have not
number
filed.
9.
Yes, yes. So in case we don't.
Who is
file-
representing 9 today?
My lord, I'm representing.
You are representing.
Yes, my lord. My lord, here, my lord, the projects, the fund is getting lapses, my lord, because of the litigation, my lord. So their public interest demand that should be disposed of at earliest, my lord. There's an urgency, my lord. And the last time when it was taken up on 20 June, my lord.
Hmm.
The petition appellant sought for filing of rejoinder, but although it is not required, it's a writ appeal, my lord, it's based on the record.
no, my lord, the question is the interpretation of Jagdish Mandal judgment in tender matter, whether this judgment will be applicable or not.
Hmm.
On pressing the ratio laid down in Jagdish Mandal case, the honorable single judge has quashed and set aside my read petition. It was listed before the honorable Chief Justice. My contention before the honorable Chief Justice bench was that Jagdish Mandal case may not be applicable in this case. If it is applicable, then court must look into whether decision of the tendering authority by impugn notification is arbitrary or irrational. For the arbitrary, what is irrational? I have my judgment, I have to place it, my lord. Minimum, my lord, placing facts, I'll take 1.5 hours. Then another 30 minutes for my rejoinder.
No, both sides are ready.
My lord, otherwise we are ready, man.
Some private respondent is also there. They are also not there.
They are not represented today. Just
Seven.
file.
7-8 is not here today.
Hmm?
Counsel for the private respondent.
Private respondent number 7.
In 8 are not. And then. Section 3 of the Oath Acts would also
Hmm.
be interpreting in this
And
case.
who are not represented today, Tara?
My lord,
Who are not represented today?
7 and 8 is not there. You are representing 9, right?
7 and 8. The company. Firm, 8 firm,
Correct.
7 and 8, none represents. The respondent was 7, 8, 9 you were representing.
Yes, I'm 9, I'm representing.
They are pressing hard because money is honey, honey is sweeter than mummy.
My lord,
Yeah,
ultimate
it's
lapses, my lord,
it's always
it's
there.
get lapses.
On
it will
8.
be-
On 8 November.
8 Wednesday.
Not on 8, my lord. Can it be on 6 or 7?
No, 6
6 already, 2
I have-
matters are fixed.
Then 7, my lord.
No,
8.
Lord, 7 and 8, I have fixed some important matters before this code only. I also need to.
That's
fix
why-
sometimes.
On
Eight.
9,
Method
9,
fixed.
no?
7.
7, my lord.
No, my lord, 8.
No, let us not have that negotiation. Let it be on 7 because
No, no. You see, it
7 you
cannot
will be
taken
available
up.
or not?
No, no,
Will
my
you
lord,
be
I am available, but I have matter fixed.
But give some priority. He
Yes,
says
yes,
this is
yes.
very urgent.
Let it be.
No, no, my lord.
On that day, you can obtain adjournment, no problem.
No, my lord, 7th, whether there will be a DV or not, that is also.
No, no.
I will. 7 and 8, 9 you were representing. 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 7 and 8, 9 you were represen
Well, the difficulty would be whether on 7. and
Seven.
8, there will be a DB or not.
Whenever it is there, automatically will list up, my lord.
In the
Honestly.
first DB of November,
Yes, my lord.
First DB of November, my lord,
They start from
till
6.
5th, 6th, I'm coming back.
8.
So you can have on
8.
7. Malad.
8, no, my lord.
8, Malad, why I am saying 8, Malad? Wednesday, I have some personal problem. Malad.
No,
I think my
also-
brother, he knows my lord.
Then is the
Wednesday-
second DB.
Malad, 6 or 7, any date you can
The
choose. Malad.
date will be difficult, na? I have no idea about.
First DB of the second week, my lord. First DB of the second.
Yes.
No,
First DB,
first DB, my lord,
first
yes.
DB,
First DB, Malad,
First
any date.
DB of the,
first DB
Hmm,
of
in
the
the
second
month
week
of
of.
November.
Yes.
First DB.
First
My
DB.
lord.
No,
That will
then
better.
in that even, I'm
In the
coming back.
event, anything you submit then or information may be given to the court for adjournment. The convenient date, yes,
That's interim
yes, I
order to
agree.
be continued.
interim order is there.
Yes.
Interim order.
Malad,
first
that is the main
year,
problem, my lord,
shall-
because of interim order, my lord.
So shorter date is given, na?
Yes, my lord.
No, but in any case, this case, I am of my view, my lord, after perusing the records and the interpretation of the law, I can tear apart
That's all right.
the
my lord.
government.
Basically, what they are
article-
harping on, my Jagdish Mandal. What Jagdish Mandal says is, my lord, greater public interest, my lord.
That is to be seen. my
My
lord.
lord,
Situation,
My
that's
lord,
all.
will- my lord will also appreciate only one count to enlighten them in a lighter vein. In a contract matter which is civil in nature, is there a requirement of judicial magistrate coming into and executing the affidavit? That is the real question. So therefore, my lord, that section 3 of the Oath Act, if we read with section 7 of the Oath Act, then, my lord, then that particular concept will come under section 190 of the Indian Penal Code. Any affidavit is nothing but only to bind so that a person does not commit a perjury. That's all, my lord.
My lord, all right, my
Grateful.
lord.
Will you
And-
file a affidavit in reply or any?
My lord,
I have already filed. my lord.
We have filed.
Yes.
A affidavit in reply filed by respondent number 9. Yes.
Counter affidavit act.
We are grateful.
But it may list for hearing.
huh,
List for
obviously.
hearing, my lord.
My lord, for final disposal, my lord.
For-
No more.
Then, my lord, we admit,
This is for
my lord, admit,
final, for final hearing.
my lord, that in that case, it has to be admit. And then,
Today is
in-
for
it is
admission.
not
Today
admitted.
admit. Today is for admission.
Oh.
It admits. my lord.
Admit.
List for hearing.
Interim order is there, that
Pick
means
for hearing.
admitted, my lord.
Admit.
afterward.
It is admitted.
Yes.
Interim order is there, that is admitted.
Okay.
Hmm.
Yes, interim is.
It is of Ganga. Singh. Yes, Sunar.
My lord. My lord, here, my lord, the it is agreed by the, my lord, impugned judgment and order dated passed by learned single judge, my lord, dated 26/7/2023.
Mm.
Basically, what happened, my lord, that the principle underlying by the, my lord, constitutional bench in BK Mandal case, my lord, whoever says, my lord, that if any person has done any act without intending to do gratuitously, and the other person has taken the benefits and enjoyed the act, the section 70 of the Indian contract says that the person who has received the benefit is liable to pay the compensation. So here in my case, what happened, my lord? I was allotted a contract work. I executed on my own private land, my lord.
Hmm.
Then what happened, my lord, that the respondent authority, my lord, instructed me, secretary as well as the engineer, executive engineer, saying that this additional work are required to be done. And my lord knows that I'm being a, my lord, contractor and doing that. When the senior officer was asking me to do on good faith, that they said that later on they would pay me bill amount. You don't need to worry. It's a good faith, a small contractor, my lord. I executed the additional work, my lord. That estimate was also given by the department itself. My lord. Then later I submitted the bill.
Hmm.
Now what I wrote the legal notice to them, to the department. They are not denying so far the execution of the work. My lord. It is there, my lord. So for execution, what they are saying is now that you must have executed by your own resources, since there was no any earlier approval by the government So we are not liable to pay the compensation. Then here, my lord, section 70 of the, my lord, Indian Contract Act automatically comes, my lord. But because my act, my doing of the act was not to do gratuitously, my lord. This has been, my lord, elaborately discussed in BK Mandal case constitutional bench, my lord, whereby says, my lord, under such circumstances, even though, my lord, that the contract may not be there or contract may be illegal, my lord, wrong maybe, my lord. But since, my lord, the work has been done without intending to do gratuitously, and the other party has taken the benefits, my lord. So the other party is liable to pay the compensation. My lord, here where the, my lord, learned
What's
single judge-
the value of that work?
my lord, what it's a 38 lakhs something, my lord. Only-
Respondent say. It happens everywhere.
My lord,
On request, something is done,
my lord,
subsequently payment is not.
my lord. They have taken the benefit, my lord.
Lordship, I'm on behalf of Mr. N. Parag. I standing counsel for respondent number 2 and 3. That is the tourism department. He is not appeared today, so he is not appeared today, Lordship.
Huh?
The standing counsel.
Yes.
Let the matter may be listed
Let
after.
matter may be admitted post for hearing, my lord, next day.
Lordship.
But he's just representing his senior, no?
My lord.
Are you instructed?
Lordship.
Hmm?
Lordship.
Okay. Then we'll go to first, second week of November.
Lordship.
Hmm? Your name?
Jay Saro.
This is matter. In a second week of November.
My lord.
Don't worry.
Much.
Deeply obliged.
My lord, this is statutory appeal. Conviction against the conviction order dated 11/8/2023 and sentence dated 14/8/2023 passed by Court of District and Station Judge, Special Judge Poxo, Pasighat, my lord. This poor fellow has been convicted on a wrong appreciation of the evidence, my lord. The first count, the MLC report says there was no penetrations.
Hmm?
Then further MLC report says there is no penetrations.
This same thing.
4 weeks.
List after 4 weeks.
Grateful.
Lordship, Lordship, I need time to file affidavit, Your Lordship. Yeah.
Hmm?
I need time to file affidavit.
Was the last order. Naveen Kumar, I'm a counsel for the preliminary listing, I will put it there. Affidavit in opposition. Yes, madam.
Yes, Your Lordship.
Affidavit.
Yes,
After 4 weeks.
after 4 weeks, Your Lordship.
Let us know cross. None appears. List. PB prepared, no? PB prepared. After 4 weeks.
Item number 8.
Yes, sir. You were appearing in 8.
I think it is Bini Sakma.
Yes, Vinison, Sakma.
Matter will be fixed for hearing. I have
Notice serve or not?
noticed
I have to verify.
SGR received and BP.
Already paper book ready. I have received.
PB, PPL. Also delivered, na?
As for deliver.
Hmm.
Matter will fix for Jane.
After 4 weeks. After 4 weeks?
Lordship. Right.
That's me.
May I please, your lordship, here also I have to file affidavit in reply, your lordship.
Affidavit in
Uh,
reply.
Yes, your lordship. So I have informed the other side also. Let the matter come up after 6 weeks, your lordship.
After 6 weeks.
Lordship.
AK Singh, na?
Lordship.
After 6 weeks.
Lordship.
So is to enable the learned counsel for the petitioner to file affidavit in reply. Affidavit in reply.
Yes, your lordship.
All right. 6 weeks.
My lord, here I am appearing on behalf of respondent number 4, my lord. My lord, my lord, 4 weeks time may be granted. In the meantime, my lord, will file objections to the, my lord, the IA, my lord.
My please, Lords.
Hmm.
I put the appellant here.
Hmm?
I am the appellant here. Well, filing the appeal, there is 41 days of delay. This IA is for the continuing of 41 days.
81 days cut off.
My lord, just, we wanted to file, my lord, the objection. There is a, my lord,
He has
deliberate.
the right to file objection, na?
My lord.
Yes,
Let him file. But no further.
My lord.
Hard to issue. Same cut to 6 time to file objection. Prayer stands alone. List after 4 weeks. No
Right.
further extension.
My lord. DPW.
Oblige you.
This case, I is for
IA for
condemnation delay of 17 days,
how many days?
17, 17.
70.
No, 17.
17.
Yes.
Here it is mentioned as 19.
Okay. It was correct. Yes.
Huh?
No. At the time of filing, it was 17. Now they have corrected. There was some technical defect in filing.
Hmm.
So again, 2 days has been taken. So, my lord, this judgment was passed on 2nd August 2013. On the same day, my mother-in-law has expired. So I was at my hometown to see my mother-in-law, and I came back here on 6.
Is there any document in support of your plea? No document.
No any document, but I have
No document
specifically
is filed. Yes, respondent side, any objection? 17 days delay only.
No.
No objection.
No.
Hard so and so. Give, put the names. By this interlocutory application. File under section 5 of the Limitation Act for condonation of delay of 17 days,
19.
19 days in preparing the accompanying appeal against the judgment and order dated 2/8/2023 passed in WBC number 350 of 2021. Learned counsel submits no objection against condonation of delay as spread in view of the grounds
I was for the respondent of 4 to 7.
4 to 7.
There are other respondents.
You are? Whom you are representing? 4 to 7 you are representing.
Yes.
Then 3.
Lordship 3.
Huh?
3.
3. No, 17 days delay. No. Condonable. And we have the grounds cited in the petition. No? Delay is condonable. It's connected AP
After vacation.
being WA number 30 AP 2023 after the ensuing vacation.
These lordships. Lordship and Ladyship, this is listed for final arguments today. I represent the Ministry of Finance and Ministry of Education, Government of India.
Yes.
And the answering respondents, Lordships and Ladyship, they are an autonomous institute, Northeast Regional Institute for Science and Technology. They are an autonomous body under the Ministry of Education. So Lordship, today I'll take you briefly through the facts, and then I'll take Lordship through some of the very relevant documents to our case. And then, of course, we'll deal with the grounds, and I'll support you with the judgments of the Honorable Supreme Court in that regard. So this would be how we proceed today, Lordship.
Yes. Do you want to submit something?
No, ma'am.
All it.
This will
So-
take time, but.
That's okay, Lord. We can even have it tomorrow, a day after. I'm here, Lordship, from Delhi, so I'll come with 3-4 days' time. We can continue if it requires. But I should finish by lunchtime, Lordship. I will finish by lunchtime. Let's start, Lordship, because it's been deferring. Last date also, Justice Nani Tagia came post lunch and we had to defer it because
All it.
deeply obliged, Lordship. So, Lordship, in brief, to tell you about the facts, before we even refer to any documents, I represent, as I told you, the Ministry of Education, which is the administrative ministry for NERIST, and the Ministry of Finance, Department of Public Expenditure, is the ministry dealing with all the financial and economic aspects of NERIST, that is the answering respondents. Now, what has happened is, prior to 1987, before the coming into effect of the GPF scheme, as all of you know, there was the Contributory Provident Fund scheme of the Government of India. Now in 1987, the General Provident Fund scheme came in, whereby it was only applicable to the employees of the central government. I'll show you through the documents. It was only applicable to the officers of the central government, and the others, that is the autonomous bodies, etc., were supposed to continue with their CPF scheme. Now, a declaration had to be given by September 1987. And if the declaration was not given, central government employees automatically switched off to that scheme. Now, thereafter, what happened is the autonomous bodies like NERIST have been writing to the Government of India various times, and the government refused to accept that autonomous bodies will be brought under the GPF scheme, of course, for financial repercussions, as we all know. Finally, government came with the NPS in 2004, and it was made applicable across the board to everybody. They have no issues about NPS because the concerned employees here were appointed prior to 2004. So they were all part of the CPF scheme as declared in the Board of Management meeting of NERIST. And they went on claiming for the GPF scheme, which ultimately, by a final notification dated 16th March 2000, the Ministry of Finance, Government of India outrightly rejected, saying this does not apply to autonomous bodies. This is also in accordance with the Third Pay Commission, carrying the definition of the central government employee, and the Seventh Pay Commission, carrying the definition of central government employees subsequently. Now, these people filed a writ petition in 2004 before this Honorable High Court, which was dismissed with some directions. However, please note, Lordship and Ladyship, that in 2004 writ petition, they did not challenge the notification of 16th March 2000, which is also observed by the learned single judge. Subsequently, they made further communications with the Government of India just to increase their limitation and, cover it up for the limitation, delay and latches, though limitation does not apply to the writ petitions, delay and latches apply. Ultimately, in 2015, Lordship and Ladyship, they challenged this 16th March 2000 order in a writ petition before this Honorable High Court. And this Honorable High Court, wide order dated 22nd August 2022, allowed their writ petition giving certain directions to the Government of India. So I will read that operative part of the order.
Page number?
Yes, Lordship, I'll just tell you. Patla wala file. Yes, Lordship. Where is the operative part of the order? The operative part of the order, Lordship, of 22nd August 2022, Guwahati High Court. Single bench, of course, by Justice Robin Fukan.
Just a moment, we are discussing something.
Yes, yes, please, Lordship. Volume 4, volume 4. Yes, Lordship, may I, Ladyship, may I? Yes, Lordship, in volume 4, and this is
Volume 4?
volume 4, Lordship.
Don't have a volume 4.
Where is it? This is the only file is given here.
There is a volume 4, Lordship, and on page 831 is the
I have
operative.
not
part.
received any.
Yes, you have received, everything has been served to you. Everything has
Not
been served to
available.
you, received.
Not tagged with the file. Yes, but
Lordship, the
you
last
receive it.
No.
last volume of the annexes, documents.
He has not received it. no?
Yeah, he has received, Lordship, personally, we have served it to him, and everything has been served to them, every page in my supervision, under my supervision, Lordship.
We have not
Anyway, if you
received
look
that.
at records, Lordship, the operative part,
The council says he has not received.
Lordship, we must
also
say,
available on file.
signatures are there on the receipt, Lordship, we have the signature. I know, because it was served under my supervision last year.
No, not that one.
How can you not have this operative part of the order? You were the counsel in the case. You also have the copy of the order. Let us not technically take this. You were the counsel in the
Through
case.
whom you served?
Lordship, personally, it was served to
Personally.
Mr. Duckpin, yeah, the clerk upstairs, Mr. Duckpin. And my team was here. I was here personally. It was served to him. And anyway, he was the
I
counsel
have
there.
that
So he,
copy. I'm just saying,
Yeah.
don't have the volumes.
no, anyway, you have the copy of the order because he was the counsel himself before learned single judge. So there is, I'll just read one para only, operative part
No,
of.
no, all right, that copy is not available, even not tagged with the file.
No, there would be the copy of the order, Lordship, the last order of the Justice Fukan. It will be there on the
But
records
it
of
is
the,
not here.
Page 100, 810 was asked.
which, how many
Page
pages? Yes, yes, yes. And it starts from, I'll tell you,
Received.
the order of the learned single judge starts from page 748, annexure 34 of our writ appeal. Annexure 34 of our writ appeal, Lordship, starts from page 748.
This is judgment. This one, this is judgment, no? Please see whether received or not.
No, the memorandum of appeal I have, not this one.
It is with the memorandum of appeal only. The annexures are all given. This is annexure 34, Lordship. And he has the copy of the order because he was the counsel before the learned
It's
single
not
judge.
there. was just responding to what my learned friend.
Ah,
said.
that's
Just get
okay.
some volume, that volume I don't have. That is only a thing I'm saying. I'm not making any technical.
No, you just see if you have these pages, maybe we have spiral bound it, but whereas it was submitted to the court as a file.
But their judgment copy is available here.
Yes, sir,
Page
please.
number 810.
Yes, Lordship. Please come to page 831 of that. The last para, operative para, I just want to read that to make Lordship and Ladyship aware what exactly was the directions to the government so that we can take it forward from there, Lordship. and Ladyship.
831.
The last para 28, Lordship. I'm referring to para 28 of Justice Fukan's judgment. Does Lordship and Ladyship have it?
28.
Para 28, yes. So with your permissions, I'll just read it. In the result, I find sufficient merit in this petition and accordingly the same stands allowed. By a mandamus of this court, the respondent numbers 1 and 2 are directed, respondent number 1 and 2 is Ministry of Education and Ministry of Finance, are directed to approve introduction of pension scheme to the employees of NERIST in terms of the proposal submitted by the Director NERIST by letter dated 23/10/2006 without making any distinction between the employees of NERIST who have joined the institute prior to 16th March 2000. 16th March 2000 is the date of the impugned notification of Government of India, and those who have joined after 16th March 2000. And this would be the period 2000 to 2004 before coming into effect of the new NPS, the National Pension Scheme. Within a period of 3 months from the date of receipt of a judgment and order of this court, the petitioner shall obtain a certified copy of this judgment and order and place the same before the respondent number 1 and 2 within a week from today. The parties have to bear their own cost. So this was the operative part of Justice Fukan's judgment. Now what happened is we received this judgment on 26th August. Government took a decision to file a writ appeal, and this was therefore filed on 21st November before this honorable court. And that's how we are here, Lordship. Now, I would like to take Lordships through some of the important annexures. So first, I will take Lordship to Annexure 1, which is on page 174. It starts from 162 to 194. I will specifically refer to page 174. This is a copy of the Memorandum of Association and Rules of NERIST, Lordship. So on page 174, if we have the last point, that is 39, it says, the Board of Management shall be the principal executive body of the institute and shall have the power to take all necessary decisions for the smooth and efficient functioning of the institute. Next, I will take Lordships and Ladyship to page 195, Annexure 2, and I will specifically take Lordship and Ladyship to page 200, point number 17 of this Annexure 2. This is a copy of minutes of second meeting of the Board of Management dated 28th July 1984. NERIST was established in 1983 by Gyani Zail Singh, the then President of India, under the Northeast Council. And 4 or 5 institutes were established at the as the Centrally Funded Technical Institute, CFTI, that's what they call here. So if Lordship and Ladyship has page 200, I will read point number 17. Contributory Provident Fund. A compulsory contributory provident fund shall be constituted, maintained and administered for the employees in accordance with the provision of the rules made by the management committee for this purpose. So what are we talking of? CPF, Contributory Provident Fund. Now, Lordships may come to page 210, Lordships. Page 210 is part of Annexure 3, which is a copy of the minutes of the
Page number,
page number 210, Lordship.
210.
Yes, Lordship. This is a copy of the minutes of 6th meeting of the Board of Management, NERIST, dated 16th May 1986. I am bringing you to the clean copy of this because the original attached herein is slightly illegible. So let us look at the clean true copy. And I bring you to point C, agenda item number 6, point C. Lordship and Ladyship may have it. CPF scheme, which was earlier adopted by NERIST. CPF scheme for the employee of NERIST with retrospective effect, that is from the date of their establishment, was approved. A draft rule for this purpose, which is appended as Annexure 2, which is in conformity with the IIT statutes and Act 1961 was adopted. So this is in conformity with the Indian Institute of Technology Act and statute. Next, Lordship and Ladyship, I will take you to Annexure 6, page 221. 221. And this is dated 1st May 1987. And this is a copy of the OM dated 1st May 87 of the 3rd Pay Commission report and the 7th Pay Commission report, which I will subsequently show you. Now, as per this Office Memorandum of the Government of India, Annexure 6, let us read the subject, Lordship. Changeover of the central government employees from the Contributory Providence Fund scheme, that is the CPF scheme, to pension scheme, that is the GPF scheme. Implementation of the recommendation of the 4th Central Pay Commission. The undersigned is directed to state that the central government employees who are governed by the CPF fund scheme have been given repeated options in the past to come over to the pension scheme. The last such option was given in the Department of Personnel and Training, OM dated 6 June 1985. However, some central government employees still continue under the CPF scheme. The 4th Central Pay Commission has now recommended that all CPF beneficiaries in service on 1st January 86 should be deemed to have come over to the pension scheme on that date, unless they specifically opt out to continue under the CPF scheme. So what is to be noted here, Lordship and Ladyship, is this is applicable only to central government employees. Now, Lordship and Ladyship may have Annexure 7, which is on page 230, and I will take you to page 231. Agenda item number 6. Annexure 7. This is a copy of the minutes of 29th meeting of BOM dated 11/11/92.
Page number 231, na?
231, I will take you to agenda item number 9, Lordship and Ladyship. This is agenda item number 9 reads, General Provident Fund cum Pensions cum Gratuity Scheme for the NERIST employees. Shri Bhattacharya and Shri Nagarajan of the MHRD informed that the Finance Ministry has taken a policy decision that the GPF cum gratuity scheme should not be permitted for the autonomous bodies, institutions. The chairman instructed Professor Fukan to obtain a copy of the guidelines from the MHRD for further consideration. So this letter is a part of the minutes of the board meeting. So 1992, they have been informed by the Ministry of Finance, and discussed in their board meeting, look, guys, autonomous bodies, you don't get the GPF. It is only applicable to central government employees. You please carry on with your CPF scheme or any other scheme that you want with the support of LIC, EPF, any other organizations. Now, Lordship may please have, Lordship and Ladyship, may please have their impugned notification in the writ petition before single bench dated 16th March 2000.
Page number?
Page number 244, Lordship and Ladyship. This is the main impugned notification of 16th March 2000, which they ultimately challenged only in 2015 in the writ petition before the single bench, the order of which we are here in writ appeal. I will read that. There is a clean copy. If Lordship wants me to read the clean copy, I can read that also. But this is quite clean to read, so I will make the efforts. The Department of Expenditure has been receiving a number of proposals regarding introduction of pension scheme on Government of India pattern for the employees of autonomous bodies under various ministries, departments of the Government of India. Such proposals have not been approved, mainly for the reasons given below. Various reasons given, I'll just read the first reason. The cost of introduction of pension scheme is much higher than the GPF scheme. The cost on pension scheme keeps on increasing with every increase revision in the scales of pay, pensionary benefits recommended by the successive pay commission set up by the government. The letter goes on. I will come to the next, the last para number 4 on page 245, which is the operative para, which says, in view of the above, we have been advising autonomous bodies under various ministries, departments of the Government of India to continue to follow the CPF scheme on the autonomous bodies. If they so desire, they may work out an annuity scheme through the Life Insurance Corporation of India based on voluntary contributions by the employees and without any contribution from the government, or the employees may join the pension scheme introduced by the Ministry of Labour for the PF subscribers. It may please be noted that introduction of pension scheme on Government of India pattern to the employees of the autonomous bodies should not be agreed to as a rule. Any exception in this regard should be referred to this department, and this is signed by Mrs. Usha Mathur. So this is their impugned notification before the learned single bench. Now I will take you, Lordship and Ladyship, through some subsequent important documents also. Lordship may be pleased to have Annexure 16 on page 257. Annexure 15 on 257, sorry. This is a copy of the letter dated 9 January 2000. No, I'm not taking that. Annexure 16, yeah, Annexure 15 I'm taking, okay. 9 January 2002, page 257, Lordship and Ladyship. This is written to the Director NERIST from the Government of India, MHRD, which is the Administrative Ministry for NERIST. Let us look at the first para, Lordship and Ladyship. Pension scheme for NERIST employees. And he is referring to, I'm directed to refer to your communication number so-and-so dated 28 December 2001 on the subject mentioned above, and to say that the status position of various decisions arrived at in the above mentioned meeting are as under. The institute should prepare a self-contained proposal for introduction of pension scheme to the employees of NERIST who have joined the institute prior to 16th March 2000, the date on which the Ministry of Finance directed various ministries, departments not to extend pension scheme to autonomous organizations under their control, along with the approved pension scheme of the institute. While preparing the proposal, the institute may also indicate the financial implications required to implement this scheme to its employees. As soon as the proposal is received, the same will be processed and the approval of the Ministry of Finance will be obtained for introduction of pension scheme for NERIST employees. It may also be indicated in this proposal which pension scheme will be made applicable to the employees who have joined the institutes on or after 16th March 2000 and its progress for adoption. This was never received by the Government of India till date. Now, Lordship may have Annexure 16, page 259. Page 259, Lordship. 259 and 260, I will read, Lordship. Now, this is from Director Nerist. And
Page number.
page number 259, Lordship. Now, they write, Lordship, in the first, second, third, fourth line, as directed, we have prepared the financial implications in this regard, and the following points have been kept in mind at the time of preparation of the same. And they give a list of points that they have prepared. Next page, 260, Lordship and Ladyship may have a look. To implement the pension.
This self-contained proposal.
Yes, this is not a.
Introduction.
Yes,
Of
Lordship.
the pension scheme.
Yes, Lordship. They have just put in
That
these.
means they have adopted.
They have not adopted.
They have not adopted.
CPF chal raha hai, Lordship, because CPF was approved by them in the BOM, as I read to you earlier, that Contributory Provident Fund is approved, adopted, and it is in line with the IIT statutes of 1961. That is, I read to you, the first document that I read to you. Okay. To implement the pension scheme, I'm reading page 260, Lordship and Ladyship. To implement the pension scheme in Nerist, Institute has to create a pension fund so that employees may be paid pension out of the interest earned on the fund created for the purpose. So what they are saying, that we'll have to create a fund. They don't have a fund. So this is an implied position. They don't have a fund. Okay, now, Lordship, in reply to that, 8th Feb 2002, government sends a letter to the Director Nerist. It is on page
That
261.
pension fund was prepared or not thereafter? Pension fund.
Pension fund was not there. So that is not the till date, Lordship.
is
They have
the
not been
root
able to
cause.
submit
That is
any.
the root cause.
That is the root cause. I'll show you the comparative letters. Once they are saying government has to fund us. Next, they are saying, no, we have fund for 5 years. Next, they are saying, no, we have fund for 10 years. Government is saying, if you are self-sufficient, like IIT is governed by the pension scheme because it is mentioned in the IIT statute that the pension fund of Government of India will be made part of the IITs. In the universities, governed by UGC, UGC is taking the full financial responsibility. So Government of India does not have to take the financial responsibility. Government told them, if you can take your financial responsibility without burdening the Government of India, please go ahead, we will approve it, no issues. But they are wavering until today, no consolidated financial proposal with balance sheet, profit and loss account, cash flow statement, nothing has been submitted to the Government of India till date, even after 23 years. Even after 33 years, I would say, because we are talking from 1992, Lordship. Okay, Lordship may have page 261. And this is Government of India's reply dated 8th February to the earlier letter. And I'll just read para 4. Rest of the things are kind of a matter of records, which shows that what they have considered and what government asked, it is not in consonance with them. Para 4, I'm just reading for reference. Apart from the above, the institute has failed to prepare a self-contained proposal on this subject and submitted to the Ministry for processing the same for obtaining the approval of Ministry of Finance. Furnishing of information on a piecemeal manner will only delay the matter and create unavoidable delays, which will complicate the matter further. To this situation, the institute is advised to immediately prepare a self-contained proposal incorporating the aspects mentioned in para 3 above and submit the same to this ministry. The institute may clearly indicate which pension scheme they are going to adopt for the employees who joined the service of the institute after 16th March 2000. So Lordship may note the date on 8th February 2002, government is writing back to them in response to their earlier letter. Okay, look guys, please give us a consolidated statement, a substantive statement of financial capability, and we will discuss with the Ministry of Finance and get it through. That doesn't come through. Let us look at Annexure 17, page 268, Lordship. This is again from the government, letter dated 1st August 2003. So that government, I'm just trying to show how government has been continuously communicating with them. And this is written by Mr. Shastri, desk officer. I'm directed to say that the matter regarding introduction of pension scheme to the employees of your institute has been considered and submitted to the Ministry of Finance through Integrated Finance Division of the department. This issue has been considered at length in the Ministry of Finance and intimated to the department by their communication dated 29 July 2003 that it is not feasible to introduce pension scheme in NERIST at this belated stage, as the scheme in question has been since withdrawn the Government of India as a policy. So this is a policy decision of the government with the effect from 16 March 2000, which was communicated to them. In view of the above, the institute is requested to consider adopting new pension scheme being formulated by the Government of India for its employees, which came into effect in 2004. I will read the next Annexure 8, Lordship, page 18, page 270.
217.
270. Now, this is from Ministry of Finance and a very strong letter. Joint Secretary Srimati Sushma Nath writes. I will read the second para, Lordship and Ladyship. It has been observed that proposals for introduction of pension scheme on Government of India pattern for the employees of the autonomous institutions continue to be referred to the department in spite of clear-cut instructions in this regard. Most of the cases referred to this department could have been decided by the Integrated Finance Division of the concerned ministry's department. Therefore, instructions contained in this department's DO letter of 16th March 2000 are reiterated for strict observation and compliance. A copy of DO letter 16th March 2000, which is the MPU notification, is also enclosed for ready reference. So government is continuously informing them, look, you cannot be at par with Government of India employees because you are different, you are an autonomous body.
What is these documents, 16 March 2000?
This is the notification by
Yeah,
which,
page number.
yes, Lordship. This is 244 is the original photocopy, and page 246 is the clean copy. Now, Lordship, the answering respondents, they filed a writ petition before this honorable court, writ petition number 131 of 2004, which is Annexure 20, starting page 273.
Hey, page number 246, there is no date.
What? Pardon, Lordship?
In page number 246. There is no date. Oh,
It's given up.
here in the top.
Yeah, 16th
On the
March
top.
2000 on the top. Yes, Lordship.
Hmm. Page 246. Hmm.
Yes, Lordship, may Ladyship may please have Annexure 20, page 273. This was the writ petition, first writ petition that the answering respondents had filed in 2004 before this Honorable High Court. And I will take you to para 3 of this petition on page 277. Lordship, here in para 3, it is stated an affidavit in opposition has been filed on behalf of the respondent number 3 and 4. And the main contentions in the affidavit in opposition of the respondents 3 and 4 is that the nearest authorities have no objection in implementing the
Yes.
scheme, provided it is provided and financed by the government of India. So they make their own admission recorded in the order of the Honorable Court that if it is financed by government of India,
Conditional.
yes, yes. So I will further read scheme. It is provided and financed by the government of India. Mr. N.N. Saikia, learned senior counsel, assisted by Mr. Ajina Pang, referred to the various statements made in the affidavit in opposition filed on behalf of the nearest authority, has fairly submitted that the nearest authorities will rather be happy if the schemes are allowed to be introduced by the government of India on their financial assistance. So they are burdening government of India. Now you see how they keep changing the stand. I will show you Lordship and Ladyship subsequently. Now Lordship and Ladyship may have Annexure 22, page 296. Before that, I will read page 295, Annexure 22, because that's a collective document. Annexure 22 starts page 295. I will just read only the last para, Lordship and Ladyship. Now, this is a letter written to the Director MHRD by Mr. Ashok Singh, the Registrar of.
Then the
Yeah.
last paragraph, it is to be mentioned that the institute is self-sufficient.
Yes, Lordship. It is to
take
be care of
pension
mentioned that the institute
liabilities
is
of
self-sufficient to take care of.
pension
Now you see the contradiction. Before the court, they say we need financial assistance from the government. And here in 2006, they are saying it is to be mentioned that the institute is self-sufficient to take care of pension liabilities of employees based on the deposit cum interest accrued concerning institute contributions since inception till 2017-18. And I will show you, but just to point out at this point, there are no rules by the government of India to shift funds from CPF to GPF, because both of them are entirely different schemes and there is no rule for inter-fund transfer. So this cannot happen. Now, Lordship may have the next page. That is page 296. This is also from the government of India. It says, I'll read it. I'm directed to refer to the discussion held by you with the undersigned during your visit to this ministry on 4th August 2008 on the subject cited above. Towards this kind, attention is invited to this ministry's letter number so-and-so dated 1/8/2003, wherein the institute was informed that the proposal regarding introduction of pension scheme on Government of India pattern to the employees of autonomous bodies, that is NEDIS, Itanagar, had not been agreed to as a rule with effect from 16 March 2000 by the Ministry of Finance, letter dated so-and-so. Further, it is informed that recently in the case of Slyett Longowal also, a meeting was convened wherein the financial advisor, HRD, informed Honorable HRD Minister about the decision of Government of India not to extend the GPF scheme to any autonomous organization with effect from 16th March 2000. Accordingly, the institute is advised to consider adopting new pension scheme for all its employees as there is no change in the stand of the government. Now, I will request Lordship and Ladyship, I know I'm taking you through a few documents, but it is very important that we know the documents. Page 23, sorry, page 300, Annexure 23.
200,
Page 300, Lordship.
300.
Annexure 23. This also, this letter categorically again says, look, your letter of 20th May 2013. Now, at this point, I will just recapitulate the order of the learned single judge, where he is telling us to go by a letter of 2006. And I showed you, Lordship, 2006 letter really contains nothing. There is no substantive proposal. But this impugned judgment says that we should consider that letter and implement the pension scheme. And this is 2013, we are saying. The matter was examined carefully in this department, and MHRD, by its department's OM dated 8/7/2013, was informed of the reasons for not concurring with the proposal. So Ministry of Finance is writing this letter to the Finance Secretary, and Finance Secretary further intimates the MHRD. So we are in 2013. Where is 2006 letter that Honorable Single Judge has asked us to implement? Now, Lordship may have the Annexer 28, no? Page 301. Annexer 23, page 301. And I will read. Proposal for implementation of GPF cum gratuity cum pension scheme in the Northeastern Regional Institute of Science and Technology, NERIS, Itanagar. The undersigned is directed to refer to the Department of Higher Education Communication dated 20th May 2013 on the above. In this regard, it is stated that this department is not in favor of the proposal of implementing GPF scheme for the employees of NERIS due to the reason mentioned below. On the recommendation of 4th Central Pay Commission issued on 1st May 1987, giving an option to CPF beneficiaries to come over to the pension scheme, that OM was in relation to central government employees who at that time were being governed by the Contributory Provident Fund, that is the CPF scheme. And then the government goes on to explain it, categorically saying that if the instant proposal is agreed to, the similarly placed autonomous bodies would also demand the same dispensation. Therefore, NERIS, in the earlier paragraph, it is stated, accordingly, the employees of NERIS covered under the CPF scheme can also opt for the new pension scheme. Now, Lordship may have Annexer 25, page 305. पेज कितना है पहले? 212 कितना है?
We'll take break for 10 minutes.
Please, Lordship, please.
Continue.
I'll make my submissions tomorrow.
Deeply obliged, Lordship, and Ladyship, deeply obliged. Also mentioned that this is an autonomous institution. I will just take you through 3 more annexes, and then we will go to the grounds and the judgments straight away. So Lordship and Ladyship may have Annexer 25, page 305. I will just read para 2, that is enough in the light of all the background communication I read. This is a letter of 4th August 2014. These are days just prior to their filing the writ petition of 2015. The Ministry of HRD has not been able to sanction GPF cum pension scheme to the faculty and staff of NERIST so far. So this is a clear letter from the Government of India. Lordship may have Annexure 28, page 310. And just point 3, subclause 3. Point 3, subclause 3, page 310, Annexure 28. I'll just read. The expression for many years, government is writing to NERIST, is not clear to us. NERIST said we have fund for many years, so that is where the government is saying.
Where from you are reading?
Lordship, point 3, subclause 3. The expression for many years is not clear to us. NERIST is requested to clarify whether they have funds for 10 years, 12 years, or 14 years. And this letter is dated 24th February 2015. So they have not been able to still submit a substantial proposal to the government. And the last annexure before they filed their writ petition is Annexure 30, page 313. This is the last of the annexures that is relevant for our case. I will just read this letter of the Government of India, Deputy Secretary. To Dr. P.K. Das, Director NERIST. Introduction of GPF cum gratuity cum pension scheme in the NERIST. I am directed to refer to your letter of 2015 dated 5th March 2015 on the subject cited above. The matter has been re-examined in consultation with the Integrated Finance Division of this ministry on the issue relating to conversion of CPF amount for pension payment, which will imply the change in the terms and conditions for contribution to CPF. Integrated Finance Division has advised that CPF and GPF cum gratuity cum pension scheme are totally two different schemes prescribing different benefits to their subscribers. Under the CPF scheme, the employees are not entitled to monthly pension, and the contribution under CPF cannot be utilized for disbursing pension as per the provision of the scheme. There is no rule for organization to switch over from CPF to GPF cum gratuity pension scheme. Government has made it very clear. As already informed, NERIST, through various communications of this department, that initially the proposal was not implemented because the institute could not send the proposal in proper form to the ministry within stipulated time. In the meantime, Ministry of Finance issued the instructions on 16th March 2000, advising all ministries and departments not to allow GPF cum pension cum gratuity scheme in any of the autonomous organizations. It has already been informed to NERIST that Minister of HRD had referred the proposal to Ministry of Finance for sanction of GPF cum gratuity cum pension scheme to NERIST many times in the past. But the Ministry of Finance has not agreed to the proposal on the grounds, since liability on account of pension keeps on increasing with every increase, revision in pay, pensionary benefits. Moreover, the acceptance of the proposal of NERIST would lead similarly placed autonomous bodies demanding the same dispensation. In view of the position stated above, it is regretted to state that the proposal for introduction of GPF cum gratuity cum pension scheme for employees, faculties, and staff of NERIST Itanagar cannot be agreed at this stage. Government has been very clear. Just one letter I will reiterate, because that is what the Honorable Single Judge has asked us to implement. The letter of 23rd October 2006, and this is page 295. Annexure 22.
295.
Yes, Lordship. I have showed you, but I'm repeating just because I'm going to the grounds. I just wanted to just repeat that once again. Because this is the letter by which Justice Fukan had asked us to implement the order.
Yes. The last paragraph.
Yes, I read it to you. So just wanted to just reiterate. And one more document I would like to show Lordships is on page 228. This is report of the Central Pay Commission, 7th Pay Commission. This starts at 227, report of the 7th Central Pay Commission. And prior to this, we have report of the 3rd Central Pay Commission, 1973, page 225.
297.
No, Lordship, Ladyship, 227. 227. 225 is third pay commission, 227 is seventh pay commission. If Lordship and Ladyship has it on page,
Outside the remit of seventh CPC, Central Pay Commission.
yes, Lordship, this is the
All
report of the
bodies,
third. I'm
societies.
just coming to the third first, so it will be
Hmm.
a reference. Third is on page 226.
Hmm.
I'm just reading para 5, Lordship.
Hmm.
The expression central government employees used in our terms of reference has nowhere been defined in the Constitution. We have not been able to lay hands on its precise definition in any statutory regulation. There is a reference to the term government servant in some of the service rules governing the government employees, such as Central Civil Service Conduct Rules 1964 and the Central Civil Service Classification, Control and Appeal Rules 1965. These service rules, however, indicate only the categories of persons to whom these apply. We have considered all persons in the civil service of the central government or holding civil posts under that government and paid out of the Consolidated Fund of India to be central government employees. So there is, in the terms of reference of third Central Pay Commission, this is what they have defined. Seventh Central Pay Commission now clears it out. On page 228, if Lordship and Ladyship has, page 228. There is a table given in the scope of analysis, if Lordship and Ladyship has a look at it. And personnel who are excluded and outside the remit of 7 CPC autonomous bodies mentioned there. So therefore, autonomous bodies are not central government employees. Government has categorically classified. Now, Lordship, I will take you to the grounds in the writ appeal. And we will give you the compilation of the judgment. So you can give 2 sets to Lordship and Ladyship, 1 to my friend, Mr. Panjik. We're just giving you the compilation of the judgments that we will refer, so it's easy for you. I have also given a synopsis of each judgment, mentioning the relevant paragraphs of the judgments that we are referring to. So if Lordship and Ladyship has page 117 of the writ appeal, that's where my grounds start from,
117.
of the writ appeal.
Hmm. 33.
Yes, Lordship and Ladyship, give me the judgments. My compilation. My first ground, Lordship and Ladyship, is delay and laches. They are challenging a notification of 16th March 2000, when? In 2015. They had a writ petition filed in 2004. They do not bother to challenge the 16 March 2000 notification then. Still, we would have said it is within reasonable time. Courts would have used their discretion under Article 226. Okay, 4 years, okay, maybe in the interest of a welfare state. But in 2015, they first challenged this. Therefore, my first ground is on the issue of the doctrine of delay and laches. The Honorable Single Bench should have dismissed the writ petition in limine. Unfortunately, if Lordship and Ladyship reads the order of the Honorable Single Bench, you may read it at your leisure. Nowhere, and I'm very categorically noting it down, nowhere has the Honorable Court asked my learned friend, because they were the petitioners there, why there is a delay of 15 years. Neither they have sought condonation of delay. Unfortunately, learned ASG was appearing on behalf of the government. He also never brought up the issue of delay and laches. And there is a Supreme Court judgment which says even if the Government Council does not bring in certain issues, delay and laches are a question of law. The Honorable Court should have suo motu taken up this issue and resolved it before going into the merits of the case. And if Ladyship and Lordship may be pleased to read the judgment and the pleadings, you will nowhere find that delay and laches has been even discussed in a petition which is challenging a notification 15 years later. So my first issue is doctrine of delay and laches.
What is copy of this citation?
Yes, Lordship, I will tell you which are the judgments. I will tell you one by one.
It's
I'll be taking the judgment.
here, no? It is here.
Yes, Lordship. I just wanted to bring out the ground and then I'll take you through the judgments. So the first judgment that I will be referring to is State of Jammu and Kashmir versus R.K. Zelpuri. It is there in your compilation, Lordship, page 10 and 11 of your compilation. And I'm reading para 26, 27, 28, the last few paras of the judgment. The next 2-3 judgments I'm going to give you is on doctrine of delay and laches, which was never considered by the learned single bench and the parties, both. I'm reading para 26, Lordship and Ladyship. In the case at hand, the employee was dismissed from service in the year 1999, but he chose not to avail any departmental remedy. He woke up from his slumber to knock at the doors of the High Court after a lapse of 5 years. Here just 5 years, and look how harshly High Court is talking, and here 15 years.
More than 15.
Yes, yes, Lordship. The staleness of the claim remains stale, and it could not have been allowed to rise like a phoenix by the writ court. Look at the harsh language Honorable Supreme Court is using. The grievance agitated by the respondent did not deserve to be addressed on merits, for doctrine of delay and laches had already visited his claim like the chill of death, which does not spare anyone, even the one who fosters the idea and nurtures the attitude that he can sleep to avoid death and eventually proclaim Deo gratias, thank God. Another aspect needs to be stated. A writ court, while deciding a writ petition, is required to remain alive to the nature of the claim and the unexplained delay on the part of the writ petitioner. Stale claims are not to be adjudicated unless non-interference would cause grave injustice. The present case, needless to emphasize, did not justify adjudication. It deserved to be thrown overboard at the very threshold, for the writ petitioner had accepted the order of dismissal for half a decade and cultivated the feeling that he could freeze time and forever remain in the realm of a constant presence. I mean, very poetic, but very hard words from the Honorable Supreme Court. The next judgment that I am taking up, Lordship and Ladyship, is City and Industrial Development Corporation versus Doshu Adarshi. This is also Honorable Supreme Court judgment.
Page numbers.
Yes, Lordship. I am taking you to page 18 of the compilation. Lordships have it? Yes. Para 19. I'll start with para 19. Para 19 says, it is well settled and needs no restatement at our hands that under Article 226 of the Constitution, the jurisdiction of a High Court to issue appropriate writs, particularly writ of mandamus, is highly discretionary. The relief cannot be claimed as of right. On the grounds for refusing relief is that, one of the grounds for refusing relief is that the person approaching the High Court is guilty of unexplained delay and laches. Inordinate delay in moving the court for a writ is an adequate ground for refusing a writ. The principle is that courts exercise public law jurisdiction, do not encourage agitation of stale claims and exhuming matters where the rights of third parties may be accrued in the interregnum. Para 22. In our opinion, the High Court, while exercising its extraordinary jurisdiction under Article 226 of the Constitution, is duty-bound to take all the relevant facts and circumstances into consideration and decide for itself, even in the absence of proper affidavits from the state. So here, if the learned ASG has not mentioned delay and latches, the court should have suo motu taken it. That's what Supreme Court says. Even in the absence of proper affidavits from the state and its instrumentalities, as to whether any case at all is made out, requiring its interference on the basis of the material made available on record, there is nothing like issuing an ex parte writ of mandamus order or direction in a public law remedy. Further, while considering validity of impugned action or inaction, the court will not consider itself restricted to the pleadings of the state, but would be free to satisfy itself whether any case as such is made out by a person invoking its extraordinary jurisdiction under Article 226 of the Constitution.
Yes, page number 90.
Yes, Lordship. Okay, so on page 19, we were reading, Lordship. The court, while exercising its jurisdiction under Article 226, is duty bound to consider whether adjudication of writ petition involves any complex and disputed questions of facts and whether they can be satisfactorily resolved. Petition reveals all material facts. The petitioner has any alternative or effective remedy for the resolution of the dispute. Person invoking the jurisdiction is guilty of unexplained delay and laches. This is so important. The court in appropriate cases in its discretion may direct the state or its instrumentalities, as the case may be, to file proper affidavits placing on the relevant facts truly and accurately for the consideration of the court, and particularly in cases where public revenue and public interest are involved. Such directions always are required to be complied with by the state. No relief could be granted in a public law remedy as a matter of course, only on the ground that the state did not file its counter affidavit opposing the writ petition. Further, empty and self-defeating affidavits or statements of government spokesperson by themselves do not form basis to grant any relief to a person in a public remedy to which he is not otherwise entitled to in law. We set aside the impugned orders. Therefore, the next judgment, Lordship and Ladyship, that I am taking is State of Maharashtra versus Digambar. It starts on page 21 of the compilation. I will only take you to para 19 on page 30 of the compilation. Para 19 on page 30. Power of the High Court to be exercised under Article 226 of the Constitution, if it is discretionary, Its exercise must be judicious and reasonable, admits of no controversy. It is for that reason a person's entitlement for relief from a high court under Article 226 of the Constitution, be it against the state or anybody else, even if it is founded on the allegation of infringement of his legal right, has to necessarily depend upon unblameworthy conduct of the person seeking relief, and the court refuses to grant the discretionary relief to such person in exercise of such power when he approaches it with unclean hands or blameworthy conduct. Laches or undue delay, the blameworthy conduct of a person in approaching a court of equity in England, and then the judgment goes on. So laches are a blameworthy conduct. Now I will take you to Justice Arijit Pasayat's very important judgment in Shivdas versus Union of India, starting page 35. And I will come to page 36, para 5. Lordship and Ladyship may have it. Normally, in the case of belated approach, writ petition has to be dismissed. So that's very clear direction by Justice Pasayat. Delay or laches is one of the factors to be borne in mind by the high courts when they exercise their discretionary powers under Article 226 of the Constitution of India. In an appropriate case, the High Court may refuse to invoke its extraordinary powers if there is such negligence or omission on the part of the applicant to assert his right as taken in conjunction with the lapse of time and other circumstances causes prejudice to the opposition party. And then I will come to para 9. Para 9 on the next page, page 37. In the case of pension, the cause of action actually continues from month to month. That, however, cannot be a ground to overlook delay in filing the petition. It would depend upon the fact of each case. If petition is filed beyond a reasonable period, say 3 years, normally the court would reject the same or restrict the relief, which could be granted to a reasonable period of about 3 years. And normally, in most cases, we take 3 years as a reasonable period. 137 of the Limitation Act also takes 3 years. The High Court did not examine whether on merit appellant had a case. If on merits, it would have found that there was no scope for interference, it would have dismissed the writ petition on that score alone. Now, I will take Lordship. To State of MP and others versus Nandlal Jaiswal and others. And this starts on page 53, and I will take you to para 24 on page 81.
Para 24.
Para 24, yes, Lordship. Now it is well settled that the power of the High Court to issue an appropriate writ under Article 226 of the Constitution is discretionary, and the High Court in the exercise of its discretion does not ordinarily assist the tardy and the indolent, or the acquiescent and the lethargic. If there is inordinate delay on the part of the petitioner in filing a writ petition, and such delay is not satisfactorily explained, in our case, it was not even discussed, the High Court may decline to intervene and grant relief in the exercise of its jurisdiction. The evolution of this rule of laches or delay is premised upon a number of factors. The High Court does not ordinarily permit a belated resort to the extraordinary remedy under the writ jurisdiction because it is likely to cause confusion and public inconvenience and bring its train new justice. the rights of third parties may intervene, and if the writ jurisdiction is exercised on a writ petition filed after unreasonable delay, it may have the effect of inflicting not only hardship and inconvenience, but also injustice on third parties. When the writ jurisdiction of the High Court is invoked, unexplained delay, coupled with the creation of third-party rights in the meanwhile, is an important factor which always weighs, and we go to the next page, Lordship and Ladyship, always weighs with the High Court in deciding whether or not to exercise such jurisdiction. We do not think it necessary to burden the judgment with reference to various decisions of this court, where it has been emphasized time and again that where there is inordinate and unexplained delay and third-party rights are created in the intervening period, the High Court would decline to interfere, even if the state action complained of is unconstitutional or illegal. So they are saying state action is unconstitutional and illegal. Supreme Court very categorically says, even if it is so, if there is inordinate delay, the High Court shall not interfere. And I will take you to the last judgment on delay and laches. That is on page, this is Virendra Chaudhary versus Bharat Petroleum. And this is, I'm taking you, this starts on page 103. I will read para 15 on page 107. I will just read para 15 on page 107. The Superior Court's times without number applied the equitable principle for not granting a relief and or a limited relief in favor of the applicant in case of this nature. While doing so, the court, although not oblivious of the fact that no period of limitation is provided for filing a writ petition, but emphasis is laid that it should be filed within a reasonable time. A discretionary jurisdiction under Article 226 of the Constitution of India need not be exercised if the writ petitioner is guilty of delay and laches. So these are my judgments on delay and laches, Lordship and Ladyship. On my first ground, that there was exceptional, inordinate, unexplained delay, and the Honorable Single Judge has not even discussed this while passing the order, nor was it part of the pleadings also. And I've showed a judgment, even if the government spokesperson failed to bring in this issue, the Honorable Court should have suo motu asked this question. My second ground is definition of central government employee.
Page number?
This is my ground is on page 121 of the writ appeal.
Yes, definition of central government employee.
Yes. Now, why I need to see this definition, Lordship? Because I already showed Annexure 6 on page 221, where the subject says changeover of the central government employees from CPF to GPF. So therefore, we need to know what is the definition of a central government employee and whether the autonomous bodies are central government employees or not. And I have showed this question of fact on records by the Third Pay Commission and the Seventh Pay Commission report that autonomous bodies are not, they are excluded from being called central government employees. They are autonomous bodies. Hence, from CPF to GPF, this notification of 1st May 87 applied only to central government employees, and autonomous bodies cannot even agitate this. And I have explained this, Lordship, while discussing the grounds. So I'm not going into further details of it. I have also mentioned in my writ appeal which other paragraphs I've addressed. Now, the learned ASG before the single bench also has discussed the NWDA, National Water Development Agency judgment, and I have mentioned that in para 45 on page 129 of my writ appeal.
129.
Yes, Lordship, para 45. I have stated on page 129, para 45. This was mentioned by the learned ASG, Mr. Mathukato, before the single bench, and I have repeated that. Because the Honorable Supreme Court in its order dated 20th January 2015 in a matter relating to applicability of the OM Department of Pension dated 1/5/1987, which is this OM that I showed you just now, relating to switchover of central government employees in service as on 1/1/86 from CPF to pension in respect of employees of National Water Development Agency, an autonomous body established in 1982, that the employees of NWDA cannot be said to be central government employees for the sake of parity for applicability of OM dated 1/5/1987. The Honorable Supreme Court also held that the principle of parity cannot be applicable to the employees of NWDA, as NWDA cannot be treated as instrumentality of the state under Article 12 of the Constitution merely on the basis that its fund is granted by the central government. So this is my second ground, Lordship. My third ground is that the order of the learned single bench is a non-reasoned order, non-speaking order with respect to the applicability of the DO of 16th March 2000, which is their impugned notification, which clarified and reiterated that for autonomous bodies, CPF scheme shall continue and pension scheme is not applicable. So this is categorically stated, and I have explained to Lordships also on this. And if we go through the orders of the judgment of the learned single bench, this is really not a non-speaking issue, a non-speaking order. Now, my fourth ground is courts cannot interfere in policy matters. This is a very settled law and very well discussed point. And I will just take Lordship to 2-3 judgments basically on this issue. My first judgment is on page 111 of the judgment compilation. And this deals with 2 issues. Policy matters cannot be interfered with by the honorable courts, and on the topic of intelligible differentia, which they are trying to bring out. Pardon, Lordship?
Page number?
111. This is State of Maharashtra versus Bhagwan. So I will read para 26 on page 122. This deals with the concept of non-interference by courts in policy decisions and intelligible differentia. I will read para 26 on page 122. Yes, Lordship. As per the law laid down by this court in a catena of decisions, the employees of the autonomous bodies cannot claim as a matter of right the same service benefits on a par with the government employees, merely because such autonomous bodies might have adopted the government service rules, and or in the governing council, there may be a representative of the government, and or merely because such institution is funded by the state, central government. Employees of such autonomous bodies cannot, as a matter of right, claim parity with the state, central government employees. This is more particularly when the employees of such autonomous bodies are governed by their own service rules and service conditions. The state government and the autonomous body cannot be put on at par. We'll go to para 28, Lordship. As per the settled proposition of law, the court should refrain from interfering with the policy decisions which might have a cascading effect and having financial implications. Whether to grant certain benefits to the employees or not should be left to the expert body and undertakings, and the court cannot interfere lightly. Granting of certain benefits may result in a cascading effect having adverse financial consequences. Let's read para 29. In the present case, Volmi being an autonomous body registered under the Societies Registration Act, which NERIST also is. The employees of Volmi are governed by their own service rules and conditions, which specifically do not provide for any pensionary benefits. The Governing Council of Volmi has adopted the Maharashtra Civil Service rules, except the pension rules. Therefore, as such, a conscious policy decision has been taken not to adopt the pension rules applicable to the state government employees. That the state government has taken such a policy decision in the year 2005.
29.
Yes, please. The state government has taken such a policy decision in the year 2005 not to extend the pensionary benefits to the employees of the aided institutions, boards, corporations, etc., and the proposal of the then director of Volmi to extend the pensionary benefits to the employees of Volmi has been specifically turned down by the state government. Considering the aforesaid facts and circumstances, the High Court is not justifying in directing the state to extend the pensionary benefits to the employees of Volmi, which is an independent autonomous entity. Para 30, the observations made by the High Court that as the salary and allowances payable to the employees of Volmi are being paid out of the consolidated fund of the state and or that the Volmi is getting grant from the government are all irrelevant considerations, so far as extending the pensionary benefits to its employees is concerned. Volmi has to run its administration from its own financial resources. Volmi has no financial powers of imposing any tax like a state and or the central government, and Volmi has to depend upon the grants to be made by the state government. Now, so far as the observation made by the High Court that the amount available with Volmi and deposited with EPF towards the employee's contribution itself is sufficient to meet the financial liability of the pensionary benefits to the employees, and therefore is no justification and or reasonable basis for the state government to refuse to extend the benefit of pension to the retired employees of Volmi is concerned. It is to be noted that merely because Volmi has a fund with itself, it cannot be a ground to extend the pensionary benefits. Grant of pensionary benefits is not a one-time payment. Grant of pensionary benefits is a recurring monthly expenditure, and there is a continuous liability in future towards the pensionary benefits. Therefore, merely because at one point of time, Volmi might have certain funds does not mean that for all times to come, it can bear such burden of paying pension to all its employees. This is the worry of Ministry of Finance also. In any case, it is ultimately for the state government and the society to take their own policy decision whether to extend the whether to extend the pensionary benefits to its employees or not. The interference by the judiciary in such a policy decision having financial implications and or having a cascading effect is not at all warranted and justified. In view of the above discussion and for the reasons stated, the impugned common judgment and order passed by the High Court directing the state to extend the pensionary benefits to the employees of Volmi is unsustainable, both in law and on facts. Accordingly, the impugned common judgment and order passed by the High Court deserves to be quashed and set aside, and is accordingly quashed and set aside.
Okay, then
We'll continue after lunch?
for today is sufficient.
Okay. Can we continue
Will you
tomorrow?
Continue tomorrow,
Yes, Lordship, that will be nice.
because there are only 2 minutes left, one more matter. Okay. A hard change, hard. So, list tomorrow. As part of.
We can continue. I'm here, Lordship. I want to finish.
Tomorrow.
Yes, yes, Lordship. Deeply obliged, Lordship and Ladyship. I think this will be a landmark judgment because there are a lot of autonomous bodies in different states, because I appear almost in all high courts. So your judgment will be one of the first and a really landmark judgment.
Public sector also are included.
Yes, yes, Lordship. So, Ladyship, it will be a really landmark judgment, and I look forward to it, honestly. Deep dive.
One more matter. One more matter, please.
My
Yes,
lord,
okay.
here I'm for the appellant, my lord,
You are
who
for
was
the
the
appellate
respondent
court.
in the writ petition, my lord. This is a transfer matter, my lord, for the post of GDSC.
Issue notice to the respondent.
So in fact, my lord, after the filing of this writ petition, appeal, my lord, there was a meeting, my lord, on the instructions of the education department. Because here otherwise the appellant
What was
is,
the outcome in the meeting?
outcome of the meeting was that it was between the private writ petitioner and the appellant, my lord. That the appellant is going to retire in now in around 4 months only, man.
4 months on leave.
4 months only is left, man, for
Oh.
our superannuation, man. Now the writ petitioner also agreed that, okay, let her continue till then. And he will not pursue this matter also. That was what was decided in the meeting, my lord. That copies, otherwise I had furnished, my lord.
But notice served or not?
Notice served, my lord. In fact, they appeared also, my lord. And this was, my lord, a minutes of the meeting, man. There are 2 copies, my lord.
We continue with DDSC, the approval till February 2024. Jamo?
So basing on this, my lord,
This is a resolution adopted.
The
meeting.
parties has adopted the resolution, my lord. It is like I have communicated to the department. Department says we cannot accept this, my lord, because department says we cannot accept it. That has been done unilaterally by the parties, and it is a transfer matter, my lord. So I have communicated to the department, and department says we are independent to both the parties, and we will contest the case independently. Department has just
Have you filed a affidavit?
no, my lord, it is an appeal, my lord. We will
Appeal.
argue as per based on the
appeal.
record, my lord. And private, this respondent is also there, my lord.
in fact, the private respondent had filed a caveat also and they had appeared entrance, man. Now, otherwise the state has all along supported my case, my lord, that I am a lady, my lord. As for the education policy also, transfer policy, seniority and a lady should be given preference, man. All those were taken in account. This is also a case of modification of the transfer order, man. Now I am functioning there, my lord, and I will be retiring in.
Planning council said it will not be accepted.
Yes, otherwise, yes, my lord, this was at the instance of the education department also. I have 2 copies, provided 2 copies, my lord, this minutes, my lord. And it was held in the office chamber of the OSD to the Minister Education.
Jamo, you were representing respondent number 1.
My lord,
1, 2, 4, my lord. 1, 2, 3,
3,
and
4, my lord. 1, 2, 3, 4.
1, 2, 4.
My lord.
1, 2, 4. Then under secretary,
1, 2, 3, and 4, my lord. 1, 2, 4. my lord.
1, 2, 3, and 4.
Four,
My
my
lord,
lord.
yes, my lord.
Then this private respondent notice served or not?
Served, my lord. In fact, he entered appearance, my lord, and he
Ah.
contested, my lord, on 17/7/2023, my lord.
Uh,
When the impugned
who is
judgment of the
appearing?
learned
Who is
single
appearing? Who is appearing for respondent number 5?
earlier, Mr. Tara appeared, and then on the last occasion, Mr.
No.
Kamduk appeared.
In the first time he appears. No,
My lord.
not available.
On the subsequent date, my lord,
Okay,
Mr. Kamduk had appeared.
Who?
Mr. Kamduk, my lord. Dungmar Kamduk.
Yes. No,
How long is, what is the term? 2 weeks,
2 years.
2 years left for retirement.
Not 2 years, only 4 months. 4 months for the appellant to retire, man.
What is this policy guideline?
Policy guidelines I had annexed, my lord.
To take time now?
The writ petitioner was transferred, my lord, to the appraisal, my lord, and subsequently it was modified, my lord. My transfer process, it was already in process, my lord. But in the meantime, the writ petitioner was transferred. Man. Subsequently, the transfer of the read petitioner was modified and the appellant was brought in place of the read petitioner. Considering the fact that at that time only I had 1 year, 6 months, something like that left. Now I'm retiring in the month of February. It's already October is there, November, December, January, February. 4 months I have left before my superannuation. And the stay,
There is stay order, na?
yes, stay is there.
Stay order, let it be like this. After vacation, that.
Yes, ma'am. Let it be after my 6 months. ma'am.
Is for number 5.
After 4 weeks.
After 4 weeks.
Okay, man.
Interim, my lord, sorry, my lord, interim may be continued.
In table continue, okay. Hmm.
Due to inadvertent mistake, I have enacted wrong document.
And also deliver copy thereof to.
Yes, yes.
Fourteen.
My lord.
Obtain a concept of the other side.
Yes, I have informed that.
Your name?
BOV. 14, 1.
My lord, in this matter, I'll be assisting your lordships. Can it be fixed on 20th month?
20-day holiday, vacation, within vacation.
No, 20th November,
20th of?
November.
Oh, acha.
Item number 15, my lord.
14 and
14.
14 and 15, my lord.
14 and 15.
Yes, ma'am.
They are connected.
Oh, connected.
Twentieth of November.
Of life.
Like,
Lordship, may I make to mention one read petition pending matter? That, this may be listed for tomorrow for withdrawal.
Why? Why so urgent?
Agencies, their vacation is approaching.
Eh?
Just, party is pressing for,
Huh?
party is pressing for withdrawal.
Or tomorrow? Will you withdraw it?
Withdrawal.
Okay, then tomorrow.
May I? Also, I beg to mention item number 17 and 18.
17
17 and 18.
and 18.
Yes, the leading council is currently out of station.
Huh?
Leading council is currently out of station due to some difficulties.
Out of station.
Yes, there, my lord, this matter may be refixed on tomorrow, for tomorrow, my lord.
Tomorrow?
Yes,
No, not tomorrow.
my lord, the urgency is that the matter is regarding termination from service.
This is not urgent. Day after tomorrow then, Wednesday.
Okay.
Your name?
L. Teni.
Your lordship, I like to mention item number 24.
24.
I on behalf of Advocate Tok T Tang. My leading counsel is currently out of station. So the matter may be fixed on 8th of November.
Our. Have you informed the other side?
Yes, sir. Yes,
Your name?
Toreb Dai. Highly pleasure.
May it please your lordship. Lordship, I beg to mention item number 21 and 22. I have filed an interlocutory application, which is listed as item number 21, seeking leave of this court to withdraw the affidavit in reply. Affidavit in opposition.
Withdraw the affidavit.
Yes, lordship.
Huh?
Yes, lordship.
You want to withdraw the affidavit?
So since I have already served the copy of the IA.
For the?
I'm representing respondent number 15 in item number 22.
R15.
So that item number 21 is the interlocutory application filed by me.
Withdraw affidavit. When you want?
Lordship, can it be fixed after puja break, lordship?
Is there any stay order
My lord, there's no stay order.
after vacation?
My lord.
After 4 weeks?
My lord.
Deeply obliged.
My lord, this is a transfer matter, my lord. And in spite of my appointing authority and my transferring authority,
Hmm.
transferring me from Tawang to Itanagar, my lord, the DC has not released me so far.
Hmm.
And on the last date, my lord, on 3rd of this month, my lord, the learned GA, government advocate, was directed to take instructions.
Hmm?
On the last occasion, my lord, the learned government advocate was directed to take the instructions as to why I'm not being released.
Hmm. Instructions of the.
Yes, sir.
Hmm.
Well, actually, he's the loan, the survey officer there.
None?
Loan officer, loan. He's the loan survey officer.
Oh, loan survey officer. So
And 2 or 4
he's a
more.
permanent employee, no?
Yes, yes.
Hmm. Yes.
The one being the districts falling in international border, Indian army, they are acquiring a lot of land. And these are yet to be surveyed. So the one district needs more district mandals, survey officers. And honorable government had transferred 4 more mandals to Tawang,
Hmm.
and they are yet to be joined. And this is ready to transfer him, release him the moment any one of these officers join there. District authority is facing a lot of difficulties.
Where he is posted now?
He's posted at Tawang.
Tawang.
Yes.
You do not want to leave the place.
I want to leave.
Huh.
And in fact, the order is there, man, transferring me from Tawang to Itanagar,
Hmm.
to the office of the director.
Right.
My lord, that order is at page 20, man, 20, man, Annex 4.
He will transfer and posted at the
Yes,
places shown again is with immediate effect.
my lord.
Your name is,
I am at serial number 9, my lord.
your serial number 9.
9. From-
Tawang to DLM means
Director Land Management. my lord.
Land Management Office.
Office.
TTA not admissible. Why TTA is not admissible?
Yes, my lord, this is because, my lord, this transfer is on my own request, man.
On own request.
Yes, my lord. I am facing health issues, my lord, because it is in a high altitude.
Hmm.
I'm facing health issues there, and my wife and my children, my lord, are here at Itanagar. So they are also facing difficulty. And I had submitted a representation on to the Director Land Management, man.
Hmm.
Who is the authority, man?
Right.
Who is my appointing authority as well as the transferring authority, man?
That means you are not released.
I have not been released. I want to go, but the DC is not releasing me. And now the ground that has been taken, that until and unless someone joins CL, that is totally, my lord, arbitrary, my lord. He is not my transferring authority. He is not my appointing authority, my lord.
But this
And my
is-
lord will see at page 20, my lord, the transfer order, my lord. My lord is there, my lord.
Joint Director.
the release has
No,
to
no,
be.
Secretary Land Management.
Yes, man.
Who is the authority?
My lord, I am an employee of the land management, my lord. But I have been placed under the deputy commissioner for administrative purpose, my lord. But basically, I am an employee of the land management, and my authority, the authority to transfer me also is also the land
Who
management.
can transfer you?
Land management, my lord, the director.
Director.
Yes,
But by this order, the secretary has transferred.
yes, my lord, secretary, director, my lord. But this
The
basically is the,
release order has to be obtained from district authority, my lord.
The deputy commissioner.
Yes.
that is the difficulty, man. Because
And
if your lord,
posted at the places
your
shown
lord,
against
your
the-
lordship would come to page 20, my lord. Serial number 1, 2, 3, and serial number 8. These 4 persons have been transferred to Tawang, my lord.
What's the order of the deputy commissioner?
Deputy Commissioner has not passed any order as such, my lord. I have written in the,
But you made an application.
yes, I have made an application to release me, my lord.
Hmm.
He is not releasing me and as submitted by my brother, elder brother, my lord. He is not releasing because no one has joined, my lord. That is, my lord, that cannot be a ground, my. If he has certain difficulty, he has
So
to,
let him dispose of this matter.
my lord, that,
Instruction.
Hmm?
In we go through it, they'll be in detail.
Senior government advocate, deputy commissioner, zero. Transfer from Itanagar to Tourism. Field duty, Tawang district. Have you shown this letter to him,
yes, my lord, I have got a copy, my lord.
this copy,
Yes,
4th of October? Where is this copy?
no, my lord, this instruction that I have received, my lord.
Just now you have
Yes.
received. You go through it.
Yes, my lord, I've gone
You
through
are
it.
indispensable, na?
No, my lord.
And
My lord,
that
otherwise what I'm
particular station.
submitting. He has said that he will not release me till some other official
Cannot be
join.
released from Tawang district unless other officials are transferred to Tawang.
Yes,
First, without a single technical manpower, all the sensitive urgent official works of DLRS office works shall be paralyzed.
that is my lord he's saying, but he says that some sensitive, I'm not fighting anyone. I'm just measuring the land, my lord. I'm doing nothing. But my lord will
In the
see,
border areas,
my lord,
in the border areas, that is the most sensitive border.
no, my lord, there is nothing sensitive, my lord.
We feel so, na?
In terms of.
No, my lord. I'm
International
posting
border.
them. I'm posted there, my lord. Otherwise, my lord will see, my lord. If your lordship would come to page 20, man. Page 20 of
Plenty I
the,
have seen.
yes, ma'am. Yeah, my lord, sometimes what happens, my lord, the officials who are supposed to move first, sometimes it is mentioned that serial number so
It's
and
not
so.
mentioned
Yes,
here,
it's
na?
nothing there, man. So, my lord, if the DC has any problem with this order, my lord, he should write to the director, my lord, or the secretary, my lord. He cannot withhold my release, my lord, arbitrarily, my lord. He's not my authority, my lord. And if there are 4 persons who have been transferred, I have been only 1 person has been transferred out, my lord, and there are 4 persons who are coming to Tawang, man. So if they don't
In
join,
the order of the secretary,
yes, ma'am.
there is no there is nothing
Nothing, ma'am.
regarding the arrangement. Who will move first?
Yes, ma'am. So if there was a
These are not here.
yes, ma'am. If there was a condition that these persons should move first, it would mean that until and unless they come and join, I cannot be released. But it doesn't say so, order, madam.
Who is posted at your position?
There are 4 persons, my lord, that serial number 1, 2, 3, and serial number 8, my lord.
You are Mondal.
Yes, I'm Mandal.
Papumpare to Tawang.
Yes, there are
Akam Logi. He is Mondal. You are
Mandal.
also Mondal.
Yes, ma'am. Serial number 3 also.
He should move first then.
There is no such condition, my lord.
Takam Logi.
Serial number 3 also, my lord.
But
That is
he
a
not
mistake of-
before us, na.
This is a mistake of the transfer authority, my lordship.
Don't create problem. This official order should have contained that detailed arrangement. No such reaction is first.
This is not at fault.
Huh?
This is not fault, lordship.
Not,
This is not releasing because of, I mean, like, not proper order.
don't be so arbitrary, na.
But
Because your order, you say, there is
Yeah.
no arrangement who should move first and join against his post.
Right.
Then he is immediately released. He is always mentioned. Who is to move first.
Yes, yes, my lord.
Yes,
Generally,
yes.
those kinds are
Is to
ordered
be
there.
handed over the search to
Yes.
whom?
In this case, it is not there. And my lord, in case also, this person doesn't join. The deputy commissioner can always write to the director, my lord. But he is not my appointing authority. He is not my transferring
That
authority.
is
also.
different aspect. Yes.
Yes, no. My lord, here I am due to my personal difficulty, I am here. My lord, I have submitted the representation to the director land manager, especially, my lord, at page 17, my lord. At a young age of 33, my lord, I am having so many difficulties, my lord.
This is disposed of or not?
Yes, my lord. Basing on this, the transfer order was issued, my lord. Here I have mentioned that I am suffering from ailment and hypertension and all. And my wife is also posted here along with my children at Itanagar, my lord. So basing on this, my lord, I have my physical difficulty and my family, also wife and children are also suffering here. Alone she is managing. So that's why, my lord, on this ground, this order was issued and your lordship has seen TTI is not admissible because it is on my own request, my lord. So my friend, my lord, I'm only praying that my lord direction will be issued for releasing, my lord. And in case these 4 persons who have been transferred to Tawang doesn't join, my lord, deputy commissioner always initiate action, my lord, or he can write to the director. But since this order is there, my lord, and it doesn't mention who should move first, man. And I have been transferred on my personal difficulty, man. And that's why it has been specifically mentioned that TA is not available, man. TTA is not available, admissible, man. Now that when he says that I will not release you until someone does that is totally arbitrary, my lord, to my submission, man. My lord, the issue direction for release of me, and in case, my lord, none joins, my lord, deputy commissioner is always at liberty to write to the director, my lord.
Is there any other representation declining to go there? Mandal Takam Logi is the, then OL Party.
Two Mondal, one SK and one chainman has been transferred to Tawang.
Is there any representation from them? No information.
Simple matter, my lord, will dispose this
You are
matter
for?
For 1, 2 and 3 also.
for the land management.
For the land management department.
This order is passed by secretary,
Yes, sir.
not by the director. He says that he is the authority, director is the authority.
Transfer order is passed by
Director, secretary.
Director land management.
But here is the secretary.
Signed by my lord, it is the
Yes.
joint director, man.
What-
Joint
Is there any rule?
Yes, they are all official of land management department. They are all under this secretary. land
He is
management.
grade
And
4, na?
he is
Grade
the-
4 or 3,
He is the authority also.
director.
Yes, he can, who can issue this transfer order. And from this transfer order also, it clearly shows that Tawang will not be without land management staff. Instead of this one Jumdo Karwak petitioner, we are sending 4 staffs in his place. We can understand that the Tawang district is strategically located. And therefore,
We dispose of.
Yes, ma'am, it can be disposed of, ma'am.
But no appropriate transfer order has been issued.
Let one officer out of this four who had been transferred join their first lawsuit. Otherwise, Tawang district will remain without Mandal.
No, my lord, that will
Very difficult.
amount
It is
to,
not as per rule. No?
my lord, that when the DC says that,
I know you will also agree in this. We used to move first. That is not there.
that ought to have been there
And-
also in the transfer order, but
Always,
since it is not there. But we can understand the health condition of the petitioner also. That is why lordship, we are not giving him this TA for his transfer.
Without,
On his request only. we have
without TTA.
TTA,
Yes.
yes.
and my lord, one more thing, my lord, when the DC says, yes, transfer of the release of the petitioner is subject to the joining of one of the staffs. That would amount to, my lord, in fact, modifying with this transfer order.
Superior authority.
Yes, my lord. That is one, it in addition to being insubordination, my lord. So he is bound to release me, my lord. He cannot modify this order, my lord, by saying that I will not release you, my lord. When the order is there, my lord, he has to only release, my lord, and in place of me as suggested, submitted by Standing Council for the Land Management, my lord, 4 persons are going there, my lord.
Disposed of?
Yes, ma'am.
Next. I'll dispose it of.
All that.
This matter pertaining to non-release of compensation by the Power Grid Corporation of India. Now here what happened?
Land acquisition.
No, exactly not accord, but they used to pay compensation where their transmission tower was installed. So here in this case, what happened that by constructing their transmission tower, they have destroyed my house. Accordingly, a board was constituted by the deputy commissioner.
That
Additional,
means you are not compensated.
yes, my house and other property were totally,
Already the tower is installed.
they have cancelled the tower due to landslide, but my house has been washed away. And,
Huh?
my house has been washed away while constructing that tower. Construction process has been abandoned now in my place, but my property has been destroyed. Accordingly, they constituted a board and board has verified. Let me come to page 29. Page 29 is the board report. No, after submission of this board report, this Power Grid Corporation has sought for my bank account also. Also come to page 36. This is the letter written by the Power Grid Corporation to ADC to submit my bank account. Page 37. 36. May I read it? Yes. To ADC Baligan, we have received compensation assessment report caused due to soil erosion near tower location such and such and damage assessed by the committee constituted by the office of ADC Balijan, District Papumpare in respect of Tat Tajuk. That is the petitioner here. Such and such amount of rupees 1,12,33,104. Further, office of DC Papumpare with such an order has advised to release the compensation payment as per existing norms and guidelines. Kindly intimate the bank account details of ADC Balijan Papumpare for depositing the compensation amount for water release to Tat Raju and his family.
Was there any subsequent development?
No, after
After
this,
this letter was-
they have submitted I have submitted my bank account, but they have not released anything.
Yes.
So I'm seeking direction from this court to release the amount assessed by the committee.
You have furnished the bank account details.
Yes, through ADC Balijan I have submitted.
Hmm. Account details, page number 37.
Yes, 37.
Then releasing of compensation. Address to ADC. Where is the last page?
Last page is my report.
41, you see. Is not complete document. This one.
This is the same series. I have just annexed this for
No.
taking the receipt.
What's the second copy? Releasing of the compensation family. ND. What is the second page?
This page
41.
yes, this page 30 to 40 is the same copy. So I have put this only to taking
This
their.
is a separate letter, no?
Yes,
Who wrote this letter?
it was submitted to different notary, but contents are same.
Yeah, no. Document you file. Full document. Only you have tagged only one page of this letter.
But this.
Day after tomorrow you file.
Yes, obliged.
We are supported by an affidavit. Annexing there with this document. This is important document.
Yes,
Who
obliged.
wrote this letter?
No, this is representation submitted by petitioner for releasing. Full file document.
On perusal of the case record. Some pages of the documents were omitted to be annexed. Therefore, the petitioner shall file an affidavit enclosing therewith the document which is tagged full document. Document which is tagged as page number 41. Please, therefore, 9, 10, 11. So it's present with government.
May I play, my lord? My lord, in this matter, my lord, petitioner is appointed as a notary public.
Notary public.
Yes. But then what happened is that whatever he attached the document, deputy commissioner office is not accepted. He has instructed the subordinate officer not to accept his document.
His document.
Yes, without any official order. Oral has been given to him, and then many document has been not accepted. Client has to come back. This is the situation.
No, this person is Zoha Manu.
Yes.
He is a notary.
Notary for the Lohit district, there is 3 notary public. Petition is one of
Who
the.
says that his documents should not be accepted?
In fact, we could not get any official document. Deputy Commission has not passed any order, but then deputy.
Cite some example then.
Yeah, I have cited some of the examples. Yes.
Okay.
Now, before that, I will just take to that how he was appointed and then what was supposed to be done by Deputy Commission. I will come to that one. I will just take to the.
Where is your appointment order?
Yes. And you also may see page 18.
Public 18, na?
Yes, page 18 is a result. So I will just take to my result and page. You also may see page 19. Page 19.
Serial number?
Serial number 5. So this is the interview result. And after that, his name was published. I will just tag to that published in page 37. Just notification on 8 August 2023. In continuation of the office notification such and such dated 21 July 2023 by the list of notaries appointed in Itanagar capital regions, different districts were notified.
Governor of Arunachal Pradesh.
Yes, is further
is
pleased to
further
notify the
pleased
following
to
notaries
notify
shown in
the following
column
notaries
2
shown in column
against the
2.
district in the column 2 of table below.
Hmm.
So serial number 2 is against the Lohit district. So against the Lohit district, after this, Your Lordship, Deputy Commissioner has been instructed to circulate his name in the district. Is on page 38. That is a very important. Page 38. 38 serial number 10. May I read that one? Married. Page 38. Married. All deputy commissioner, additional deputy commissioner, government of Arunachal Pradesh are requested to circulate the notification in subdivision circles of the district. Now, deputy commissioner, after this appointment, after this publication, deputy commissioner was supposed to circulate his name, but he is not circulating. Instead of that, he is saying that his document should not be accepted.
The council is see, there is a list of notary recommended. Huh?
Yes,
Recommended. Your name appears in serial number 2.
that was the interview list. So now this
Page
is the
number 37.
yes, serial number 2. Yes, yes. This is the final. Yes.
Final.
Yeah, I appointed.
This has not been circulated.
After this appointment, this is issued by the government of Arunachal Pradesh. Now, on the basis of this appointment, deputy commissioner has to again circulate within the districts.
Just for information.
Yeah, information.
Mm.
But that has not been done. Whereas for other two candidates, the deputy commissioner has circulated in the district. But in the case of the
Now,
petition,
where is that order?
in fact, that is no separate order. Only the in the same order in the page 38, in serial number 10, it says that the deputy commissioner has to circulate. Page 38, serial number 10. There is no any separate order for circulation, my lord.
No circulation order has been issued.
Yes. In case of
respect of all three.
in case of other candidate, I will just take to that documents. I will just take to that document. In the case of the other two, page 34. Page 34. This is the circulation done by deputy commissioner.
Oh, yes.
So this deputy commissioner is to do same things to the petitioner, but the same has not been done. Whereas the two candidates of that particular district, this two 1, 2, 3, they were also appointed and they have been circulated. So instead of doing that, the deputy commissioner instructed the subordinate operator not to accept till the circulation is done. Now, thing is that his practice has
In
been
the
affected.
recommendation letter, there were 3 candidates.
Yes.
Huh?
Yes.
Now he has circulated the names of 2 out of 3.
No, my lord, there is 2 lists, my lord.
Two
This is-
lists.
Yes, this was selected earlier. They were selected earlier. The petitioner is appointed later stage.
Yes, government side.
So in the three candidates, 2 is of different district. 2 is of different district. Petitioner is of
Your
lower
name
district.
is yet to be circulated.
Circulated by a deputy commissioner.
Yes. You are appealing.
Yes, I'm appealing, my lord.
No, my lord, I have just abandonment in para 13. Some of the documents, it was notified with the petitioner, but it was not accepted. It's in para 13, my lord. So we have mentioned the
No,
list.
but let me.
Yes,
Yes. What is the position? Why not notified?
Position, my lord, this is coming for the first time. If your lordship see, my lord, the page number 35, this is the order dated 8 August. That is the,
I've seen.
yes, final notification. My lord, it says one more things, my lord. The second paragraph starts, my lord, the other terms and condition of the notification dated 21 July 2023 shall remain in the same. I don't know what is this notification, my lord. They have not annexed.
This was an earlier notification.
If your lordship says earlier notification, there are two conditions, my lord. One, he has to submit no objection certificate from the deputy commissioner. And that has to be punished to the law department, I think, prior to the.
No, it has surpassed. It has surpassed, and law department has appointed appointed and issued a certificate.
No, no,
So
I
there is
just-
no issue of NOC issues.
No, I'm just answering to your lordship, my lord. My lord, I am not saying that he has not submitted NOC, my lord, because the question has fallen for your lordship. I just answering to
He's
that.
just citing the procedure.
Yes. Now, my lord, why, my lord, his name has been not included in the circular, my lord. My lord, for that I have to,
Circulated in fact.
no circulated, yes, my lord, no circulated. So for that, my lord, I have to take instruction or else, since he has submitted the representation, which is pending before the deputy commissioner, that can be disposed of. That is one of the prayer, my lord. That can be disposed of, no issue, my lord.
And I will just take to because the government has appointed, and then certificate also in the page 41 for 5 years, my lord. Page 41 may take to
My
the
lord,
page 41.
appointment, all these things, my lord, no one is disputing, my
So
lord.
now question is,
Why-
deputy-
why
who is
deputy
the deputy commissioners to interfere when he is appointed to the government? Deputy commissioner
No,
is not
deputy
at all
commissioner not
government.
interfering, my lord.
This is
Why,
the-
my lord, his name has been not circulated? That is
Page
only the
number-
question.
Page 40.
Page number 43.
Yes, my lord, I have gone through
That
it.
has been disposed of or not?
Not yet disposed of. That is one of the prayer, my lord, that can be disposed of. If there is any bona fide reason, my lord.
That is not
yes.
disposed of.
Let this matter be brought to the notice of the DC.
Deputy
Lohit
Commissioner.
District, Lohit District.
Loy
Yes.
district, yes. That can be done, but no issue.
Within how many days?
My lord,
From the date of receipt, my lord, within 15 days, my lord. that
15
can
days
be-
to let
15 days.
15
15
From
days
the date of this order.
No, from the date of receipt of the order of this court, my lord. Because they have to punish the, my lord, certified
From
copy.
the date of receipt of
The
this
certified
court's
copy.
order.
Yes,
Court's
my lord.
order.
Court's order.
No, 15 days will be it.
No, no.
10 days is it's okay, my lord.
It will long vacation, na?
It's a long
You will
vacation.
not be benefited there. You will hand over a copy of the court's order.
Yes.
and From that date, 15 days. 2 weeks time.
No issue, no issue.
Give some time.
My lord, my
You
lord,
will have to work with him.
yes, my lord, with the speaking order, my lord, that has to be there, my lord.
Huh?
Because I don't know what is the reason behind. I think after this order, it will come out.
Let there be first notification, then
Yes.
you start working.
Yes, my lord.
This much.
Yes.
Yes.
Okay, notification.
Obliged.
10, 15 days.
Hey, we want another.
My lord. My lord, while making a mention, I had prayed for allowing me to change annexure 5. Maybe my lord misheard me. While making a mention, my lord, I had made a prayer for allowing me to change annexure 5 because I had inadvertently I had annexed wrong document.
Wrongly.
Maybe my lord misheard. I have changed, my lord.
All right, it is.
This is for motion, my lord. If my lord allows, I will.
Then some other order was passed, I think.
No order
Day
was
after
passed.
tomorrow and like that?
No order was
No,
passed. No.
nothing. Then all right.
Obliged. My lord, in this writ petition, I am challenging the appointment of respondent number 6 as work charge staff under Water Resource Department. State of Arunachal Pradesh, my lord, has not framed any recruitment rules in respect of work charge staff. However, the Public Works Department, my lord, has framed a scheme known as Scheme for Regulating the Appointment, Promotion and Service of Work Charge Staff under Public Works Department, 2006.
What is the impugn order?
Impugn order, my lord, will find it page 39.
He's now respondent number 6.
6, my lord. If my lord allows, I will place the scheme in hold. my lord. How recruitment of.
I'm coming.
My lord.
He's selected based on merit.
Merit.
After holding
He is
case.
placed below the petitioner in the merit list, my lord. That merit list, my lord, will find it at page number 36. Page 36, my lord. Under category DUF 3, APST, my lord. My name appears at serial number 3. Rontu Moyong, my lord. At the time when this merit list was published, my lord, I was using Moyong as my surname. Now I am using Padum. my lord.
You are in the seniority list, seniority in merit. In service contingencies are finalized through conducting 920. Oh, you are in serial number 3.
3. He is at serial number 8.
8. He is appointed,
Yes, my lord. He is appointed as work just temporary.
overriding you.
Overriding me.
You are presently working
As casual labor, my lord. If my lord allows- Others, my lord, this merit list has been used by the respondent authorities, my lord. Serial number 1 was also appointed as work charge temporary. That order, my lord, will find at page number
This is the
38.
result sheet. This is result sheet.
Merit list, my lord.
On merit.
Merit.
Thereafter, police verification,
Not necessary, my lord.
not necessary.
If my lord allows, I will place
Departmental candidate.
the departmental candidate. My lord, under the scheme of 2006, which has been framed by Arunachal Pradesh Public Works Department, that is followed in the Water Resource Department, my lord. There are 2 categories of work charge staff. First, work charge temporary and work charge permanent. Recruitment to the work charge temporary is done from the in-service casual laborers of the department on the basis of a merit list prepared after conducting trade tests. Once a person is appointed as work charge temporary, then that temporary is regularized as work charge permanent by conducting a DPC. my lord. I'll just take my lord through the relevant clause. Not page 25. Clause 7, my lord, page 25. Recruitment and promotion. The provisions of CPWD Manual Volume 3, 1984 edition, the relevant recruitment rules and orders issued by the government from time to time will govern the recruitment and
Page
promotion
number
of
25, na?
page number 25. my lord.
The proposed
Clause 7.
By strength. Where from you are reading? The 7.
7, clause 7. Recruitment and promotion. The provisions of CPWD Manual Volume 3, 1984 edition, the relevant recruitment rules and orders issued by government from time to time will govern the recruitment and promotion of WC staff under PWD. All the formality requirements like DPC, trade, etc., as per laid down provisions of manual shall be added to strictly. Next page. My lord, may kindly come to next page. Recruitment shall be made from among the casual laborers working under the department. Meaning thereby recruitment to the post of work charge temporary. Now, my lord, may come to clause 10 at page 28. Page 28, my lord, clause 10. Regularization and termination of casual workers. Regularization. As per existing vacancies under permanent category, the eligible WC staff born on temporary category shall be regularized as per prescribed procedure. This scheme is followed in the department which we are concerned with in the present writ petition, that is Water Resource Department. Petitioner and the respondent number 6, they are working under Water Resource Department. In the Water Resource Department, the last trade test was conducted in the year 2017. Thereafter,
you are working as a
casual labor.
Casual labor. And after due selection process, as per rule, you were positioned in serial number 3 of the merit list.
Yes.
However, Yeah, that respond number 6, na?
6, my lord.
6 is
Place at serial number 8.
he has been issued with an appointment letter.
Letter.
Whereas you are waiting for appointment.
My lord, I'm not exactly saying I'm waiting for appointment.
Then what is this?
I'm
What
saying
not exactly said.
his appointment is in violation of the scheme and the
Hmm.
by overlooking the merit
You
list.
talk about you, no?
Yes,
How you are affected.
My lord, I'm placed.
He is in serial number 8.
8. Yes.
You are in serial number
3.
3.
Yes, my lord.
You are waiting for that appointment.
My lord,
But 8 is already been appointed.
appointed.
Huh?
Yes.
Then what is your plea now?
I'm praying for quashing of this appointment.
His appointment.
Yes, my lord.
Is-
And a prayer for
Let me submit. You are for
1 to 5, your lordship.
1 to 5.
Yes, your lordship.
3, 4, 5. Only 6 is with you.
Notice may be issued, your lordship. Notice may be issued, your lordship.
there's an interim order. I've made a prayer for.
Where is there? See, he's in serial number 8.
Yes, your lordship.
He is issued with the appointment letter, whereas this serial number 3 is waiting. Superseded.
Yes, your lordship.
Why?
Without any instruction, your lordship, I,
No, but you see on the face of the documents.
yes, your lordship, I can see that, your lordship.
Issue notice. Issue notice. You have received notice?
Yes, your lordship.
Receive notice, as so receive receipt on behalf of respondent number 1 to 5. Extra copy of the petition along with the documents, the next day will be furnished to him within 2 days. Issue notice by registered daily post or Dusty?
Dusty, my lord.
Dusty. Dusty service of notice may be done on respond number 6. Dusty to be routed through whom? Through registry.
Registry, my lord.
Justice service to be routed through the registry of this court. Mr. So-and-so, on it. You are a government or standing counsel?
No, your lordship, junior government advocate.
Junior government
Yes,
advocate. Junior government advocate. 6, time to obtain instruction. But as on today, there is a privacy case after hearing him.
Yes,
Huh?
yes, your lordship.
So it should not be. Upon hearing the learned counsel of both the sides and consideration of the arguments made in the petition, along with the documents, more particularly penguin circle means is a circle, na?
Yes, sir.
The particularly merit list for regularization of service of the petitioner and the respondent number 6, etc. And the order of what is this? Appointment.
Appointment, my lord.
Yeah, where, order of appointment dated 9/5/2023, appointing the person, appointing the respondent number 6, who is placed in seniority in the merit in serial number 8 of the merit list. There is a prima facie case in favor of the petitioner accordingly. As prayed for till the returnable date, the operation of the impugn appointment order number WRD /C00RD, sorry, page number 50, shall remain state. Operation is state till the returnable date.
My
List in the second week. First week. Second week, Your Lordship. Second week of November.
May I please, Your Lordship? Also, this is
What
the
is
matter.
your yesterday's matter?
Yes, Lord, it's supposed to be taken up on Friday, Lordship, but there was some paucity of time because Lordship, before Your Lordship, I'll travel Your Lordship with the documents which have been annexed in my petition, Lordship. The case of the petitioner is that, Lordship. Petitioner is a class 2 contractor, Lordship.
Class 2.
Class 2 contractor. And respondent number 3, that is the joint director of Rural Work Department, Lordship. RD department has issued an LIT on 11/8/2023 for supply and procurement of materials, Lordship, under MG Narega, Lordship. That is the Mahatma Gandhi National Rural Employment Guarantee, Lordship, which has been enacted in the year 2005, Lordship. It's a central scheme. And thereafter, Lordship, the amount of tender was 6,196,115, Lordship. This, Lordship, this opening of the tender, Lordship, it was supposed to be held on 5/9/2023. But subsequently, it has been extended and it was opened on 5/10/2023, Lordship. While opening of the bid, Lordship, the other bidders, Lordship, including all the other bidders, Lordship, those who were, because the petitioner being eligible and interested in the tender participation, Lordship, he submitted.
You did not seal.
I beg your pardon.
You did not seal this tender.
Yes, Lordship, exactly, Lordship. Now, Lordship, now the interesting part, Lordship. Lordship will come at page number 25, Lordship. Lordship. This is the NIT, Lordship. Lordship, this is the
NIT.
Lordship, this is the NIT, Lordship. NIT. Lordship, the clause 6, Lordship will find clause 6 sub
Page number.
Oh, sorry, Lordship. The page number 25, Lordship.
25 format for evidence of access to availability of credit facility, bank document.
No, Lordship, the
Business on detective.
no, Lordship, this the
Page number 27.
yeah, Lordship. Lordship, I'm on the since there are
You show me the relevant document, na?
exactly, Lordship.
There you see. This is bank certificate. In page number 20.
Lordship, I am on WPC 483, Lordship.
483.
Lordship.
It is 483. I think.
I'm sorry, Lordship.
Page number?
Page number 22, Lordship. My Lordship, the colleague is supposed to be make the correction, Lord. I'm deeply obliged for that. Deeply, Lordship. Page number 22, Lordship. Now, Lordship, page number
7.
Lordship, 6, Lordship.
See.
Lordship. 6 sub clause 2, Lordship.
Shall be accompanied with earnest money.
Lordship will see. Hey, Lordship.
Hmm.
The tender shall be accompanied with the earnest
Seal
money.
and tender.
Yes,
Seal.
Lordship. See, Lord. Close to, Lordship. The tender document, may I, Lordship. Tender document duly completed in all respects should be submitted in one large seal envelope, marked as a supply and procurement material under MGREGA 2000 in respect of CD block so and so, principal document, which containing of 2 separate seal envelope each for technical and financial bid, Lordship. Now, Lordship, since this is the condition of the NIT, Lordship, and Lordship is well aware of the fact that, Lordship, and as well as the law, Lord, the tender document, the tender NIT, the condition of the NIT and the SBD document has to be complied strictly, Lordship. Now, as per, since I have submitted my bid with the conformity of the clause 6 sub clause 2, Lordship.
How in conformity? The serial number 6 Roman 2.
Lordship, I have submitted
Was
my,
it complied with
yes, Lordship.
in sealed envelope?
Yes, Lordship. Now the department, Lordship, department has says that, Lordship. Since your bid document has not been wax sealed, Lordship, since their condition of wax seal has not been provided in the NIT, Lordship. Even Lordship, assuming that, but not admitting that, Lordship, even if there is a wax seal, Lordship, that does not even deviate the entire tender process, Lordship. Because technically, once the bid is open, Lordship, if there is any irregularities in my documents, Lordship, it can be ascertained in the financial bid, Lordship. But the respondent authority, Lordship, refused to open my bid, Lordship, on this very purported ground, Lordship.
Already other bids are published.
No, Lordship. Yes, Lordship. These are the conditions, Lordship. And after, by complying of this condition, Lordship. By complying of this condition, Lordship, we have submitted a bid, Lordship. Now our only prayer is that, Lordship, whether I'll get a tender or not, that is the that will be the part of the respondent authority, because after the scrutiny of my technical bid, Lordship, as well as the financial bid, Lordship. But at least, Lordship, at least I, being a bidder of interested bidder and eligible contractor, Lordship, I should get a fair opportunity, Lord. There is a clear violation of Article 14, Lordship. And this, Lordship, condition.
Did you submit a representation?
Yes, Lord. Yes, Lordship. Lordship will find at the page, annex to D, Lordship, the last page, Lordship.
Oh dear, this one.
Yes, Lordship. Since there was some variation in page number, Lordship, so this is the representation, Lordship. The representation submitted to the department, citing a reason that since you have not given a condition in a NIT, how the bidder would come to know about that. Now, Lordship, even if the interfering of this honorable court in this, Lordship, entire NIT process, Lordship.
Wax seal.
Yes, Lordship.
Talked about this wax seal.
Lordship.
Where that clarification is, where is the clarification?
Lordship. Now, Lordship, this NIT law, this after submission of this representation, Lordship, the further evident of the malice of the respondent authority, Lordship, is evident from the fact that, Lordship, they did not even issue the speaking order also, Lordship. They simply verbally say that we cannot open your bid because there is a wax seal issue.
My lord. Yes, it is true, my lord. Nowhere in the NIT, my lord, the wax seal has been sought for, my lord.
Nowhere?
Yes, my lord. So this petition may be disposed of, allowing the prayer of the petitioner.
Simply sealed envelope is mentioned.
Yes, my lord. This may be disposed of.
Otherwise, Lordship,
directing the authorities to open their bid, my lord, that much.
What are respondents?
I am for the respondent 1 to 5. All.
By this petition. Page number. And 16, 14, 15, 16. The grievance of the petitioner is that the respondent authorities issued an NIT on 11/8/2023 for, within inverted comma, supply and procurement of materials under capital letters MGNREGA 2023-24 in respect of CD block, CD capital, block B capital, comma, Parsi Parlo, Urum Kame district, Arunachal Pradesh, inverted comma, closes, in bracket, package, press 2, Roman 2. The petitioner is a firm, no?
Lordship, represented by the power of attorney holder, Lordship.
the petitioner firm participated in the tender process by submitting all the necessary documents in an envelope,
Seal envelope.
seal envelope,
Lots.
seal envelope as per the requirement of the NIT. On 5/10/2023, the tender evaluation committee, that is the respondent number 3,
Lots. No, lots.
Respondent number 5.
Respondent number 5. Lots.
5.
Lots.
Respondent number 5 evaluated the bids of the bidders,
Lots.
except the bid of the present petitioner firm on the ground that the bidding documents were put in an envelope which was, although sealed, it was without waxing. Where did clarification has been made?
Lots of the representation, lots of, they have not passed any order. They verbally said like that. Lots.
And then the rule 6, rule no?
Clause 6. Lots.
Clause 6.
Clause 6 of
Clause
NIT.
6, Roman 2
Lots.
requires the bidders to file bid in one, in inverted comma, in one large sealed envelope.
Lots.
Marked as seal envelope, inverted comma closes. Nowhere it is mentioned that the seal must be seal on the envelope containing the bids. Bidding documents, no?
Lots.
Yes.
Must be sealed with wax. Therefore, in the opinion of this court, non-consideration,
Lots.
consideration, non-opening and non-consideration of the bid of the petitioner firm was arbitrary.
Lots of arbitrary, unwarranted, discriminatory. Lots. Based on the record. Lots.
Arbitrary and unwarranted,
Unwarranted.
being not in consonance with the
Terms of the
expression
Lots.
made in the notice inviting tender in the NIT.
Lots.
Therefore, now your petition prayer. Result is yet to be published, no?
Yes, lots.
Not
No,
published.
lots. The tender process of the other bidder has been opened, but
Next, brother.
lots.
It is submitted at the bar that the outcome of opening of the bids is not published by the respondent authority yet. Therefore, it is provided that the bid of the petitioner firm
Lots.
be opened and considered by whom? By the tender evaluation committee.
Lots.
Tender evaluation committee of respondent number
5.
respondent number 5. Within how many days?
Within
10
lots
days
of-
from the date.
within a week. No, lots. Within
7 days.
within 7 days after receiving of the order of this.
Within a period of 7 days from the date of his present. no?
Subject to his
From the
submission
date
of
of this
bid.
order.
Yes.
7 days.
Subject to his submission of bid again, my lord, because the seal cover is with us or him.
No, no, it's with the department.
Okay, so
Not necessary.
My lordship.
The B is already submitted.
Submitted,
It
lordship.
is as is where is
Lordship.
condition.
Lordship.
So they will just.
Open it, lordship. And they have to decide.
Within
it,
7 days from the date of this order.
From the day-
Let a copy of this order be furnished to learned standing council.
They will submit it. We will submit it.
Date
before
of receipt of the
authority.
order.
From the day, all right, then from the date of furnishing a certified copy of this order to the authority. Respondent number
5.
5.
Lordship.
That's by which shall be furnished by the petition.
Petitioner, lordship. Lordship, in the meantime, till my bid is should not open, lordship. The other bidders of the tender process should not be go for any further, lordship. Otherwise, lordship, I will be prejudiced. lordship.
So otherwise, after getting this information, the court has passed such an order.
Lordship. Lordship.
He should also submit it.
Necessary.
Yes, lordship.
He should also submit the certificate copy within reasonable time.
No, exactly.
So it's.
Then you file. You file. Till the beats till the beat of the petitioner farm is open.
As per the law, lordship.
Huh?
As per the law, lordship. As per the law and as per the NIT.
As per the NIT.
As per the NIT, lordship.
As per the NIT. The tender process shall not be finalized. Till
Lordship.
your case is considered.
Lordship. Exactly.
Lordship,
the item-
disposed of.
Item number 5 to 10 is the same and connected matter.
Huh?
Same matter, lordship.
5 to
5 to 10, lordship.
same.
Same, lordship. Same, there are altogether, lordship, there are the other firms whose bid as also.
Same case.
Same case, lordship, in same package, lordship. In the same package, but the other, in item number, lordship, 5, 6, 7, and 8, lordship.
Let me see then. 5, 6.
Lordship.
Let me see one by one.
Yes. Lordship may kindly come to the paragraph 3 of my petition, lordship. There's a. Paragraph 3. This is package 3, lordship. In the same NIT, lordship, they have floated with a total 9 packages, lordship. And I, being an interested. Same thing, lordship. But only the packages and the amount is different, lordship.
Same, NIT same.
So NIT same, lordship. Package number and amount is different, lordship. And the place of CD block is different.
So many persons were affected.
Yes, no, lordship. I participate in a different packages, lordship. In the same NIT, altogether there are 9 packages. So I participate.
If in the item number 5 is for second.
Item number 5 is for package number 2, lordship. Elapsed.
Same order.
Deeply obliged, lordship.
May it please your lordship. Lordship, this is a tender matter, my lord. It's a tender matter, my lord. My lord, initially there were 2 tenders issued, my lord. If my lord comes to page 32. My lord, this was a
Page
tender,
number?
page 32, my lord, of the writ petition. This was a tender issued in 2019, my lord, 15/7/2019. My lord may see the work, name and.
Where is the date?
My lord, date in the table, my lord, published date and time. In the table, the first row, my lord.
NIT and date.
NIT, my lord, date it's, in the top it's blank, but in the table they have given, my lord, published date and time. 15/7/2000.
Available on our website and from 10:30. 10:30 AM.
10:30 AM. 10 AM, my lord. Bid opening.
10:30.
That's the bid opening, my lord.
14/7/2009.
Download date start, my lord, those 10:30. My lord, my lord, but before this, my lord may see the name of the work. Construction of Coin Township Road Network, 5.50 kilometer, package 1, chainage 0 kilometer to 2.428 kilometer. Now, my lord may come to the next page. This is the amount is, my lord, 7 crore, 7 lakh and odd, my lord. My lord may come to the next page, my lord. This is also of the same date. The work, my lord, construction of Kaing Township Road Network, 5.50 km, package 2, chainage 2.428 kilometer to 4.856 kilometer. Amount is 7 crore, 1 lakh and odd, my lord.
7 to 1 lakh 20. Oh, two NIT.
Two NITs. My lord, we participated, but my lord, this NIT was cancelled.
Stays package 2.
Package 1 and package 2. That's total of 5 kilometers.
Package 1.
Package 1 and package 2.
But same construction.
Same construction, same work actually, my lord, but different phases of the work. Now, my lord, this was, we participated. After our participation, my lord, this NIT was cancelled. My lord may come to the next page, page 34.
Interest about the project
Splitted by memo number so and so are hereby stand cancelled.
Stand cancelled.
My lord may see the date 5/8/2019 down below, my lord, with the in the communication, my lord. Thereafter, my lord, we had challenged this cancellation, but this honorable court had held, my lord, that the employer has the liberty to cancel, my lord. Now, why I'm pointing out those, my lord, is to show the mala fide in that.
What are you challenging now?
My lord.
This cancellation.
Not cancellation, my lord. That is already over. Why I'm pointing out, my lord, is to show the mala fide on part of the respondent authorities. Now, my lord, another tender was floated, page 36, my lord.
Page number?
36, my lord.
36.
They have put the date now. The date is here, my lord. In the previous ones, it's not there. 2021. My lord, it is the same work, the total work in one package. Name of work and location in the table lordship will find. Construction of Kaing Township Road Network, 5 kilometers.
This is fresh NIT.
Fresh NIT, my lord. Estimated cost put to tender, my lord, 14 crores and odd. They've clubbed together those two, 7
Earlier 7 crores.
7. My lord, we participated here. The date and time of opening, my lord, it's in the, my lord, next page, my lord, page 38, my lord. Date of opening of technical bid, 12/3/2021. And financial bid would be decided later on. We participated, my lord, in the affidavit, my lord, they have stated that my authorized representative was there. The bids were opened on 12th of March. But, my lord, there was no communication to us for about 5 months about the fate of the tender. We submitted an RTI application. Thereafter, my lord, they tell us that this NIT has been, my lord, has also been cancelled. My
This
lord,
one, this third
this
one.
third one.
Third one is also cancelled.
Also cancelled. I'll show the reasons why, my lord.
This is third, not page number 38.
Yes, my lord, it's the third one.
This is cancelled.
Cancelled, my lord. After we filed
What is the
RTI,
cancellation order?
my lord may come to page 47. Sorry, my lord, 47 is my RTI. Thereafter, my lord, page 50, 50, my lord.
50.
50. This is dated 6 August 2021, after, on the same date on which we filed
Technical
RTI.
bids for construction of
Due to non-responsiveness of 4 participant firms, the above tender is cancelled by the competent authority. And they have again floated a new tender.
How this acceptance was published?
It was not published, my lord.
No reasons were assigned. That is my entire grievance before Lordship. This non-responsiveness for 5 months, my Lord, they sit tight. They do not say anything. And they float this. Even this one was not in the public domain, this cancellation notification. Now, my Lord may come to the previous page, page 49. The previous page, my Lord, page 49. This is another fresh NIT now floated.
Second time.
Fourth time, my Lord. Construction of Kaing Township Road, 5.50 kilometer. Estimated cost, same, my Lord, 14 crores. Lordship was pleased to interfere with this and had passed the stay order, my Lord. However, my Lord, and from the affidavit, we have come to know that even despite the stay order, they have opened the technical bids. The stay order was 27th, if I'm not mistaken, my Lord.
It was stayed.
This was stayed. This tender has been
13.
stayed. Yes, my Lord. This has been stayed by my Lord in this writ petition. My Lord, the reason why, my Lord, this non-responsiveness was never intimated to us, never communicated to us. From the affidavit, we have found, my Lord, that our firm's bid was claimed to be non-responsive because we have 3 other works. They say that we ought to have disclosed all the 3 works, my Lord, which is incorrect. As per the Arunachal Pradesh district-based entrepreneurship, my Lord, there were only those works which are reserved under the Act. We are bound to disclose, we have disclosed. But there were 2 other open tenders, global tenders. Those global tenders, we participated, we got the works. That was not disclosed because it was not required to. But on that ground, the real reason why, the real reason, my Lord, we have made statements in the affidavit, my Lord, in the writ petition, that the respondent number 5 is the MLA of the constituency. His wife's firm had participated in the tender. Initially, his wife's firm did not participate. That is why those initial 2 tenders, they were cancelled. This fresh tender was floated. His wife's firm participated, but the registration of his wife's firm was cancelled by the PWD department, my Lord, because she had obtained the registration on the basis of fabricated and forged documents. That is why her firm's registration was cancelled. Now they want us to be removed from the fray, and they want their own firm to undertake the work, for which they have instituted this fresh tender. This fresh tender is under challenge. My Lord, here, what I would be on, my Lord, is that what they have said is only on the basis of the affidavits. Lordship knows very well, my Lord, that they cannot supplement their reasons or supplant the reasons by way of affidavits. It has to be there in the records. Are those there in the records that they had communicated? They had produced those documents, my Lord. And my Lord, from where they found that our other works are there, that we have been awarded those other works, we had not submitted. From where did they find? That shows, my Lord, that they were acting in collusion with, my Lord, may be permitted to place 2 decisions, my Lord.
He could not participate in earlier bids.
Her
MLA's brother.
MLA's wife.
Wife.
That is why it was split. That is why it was cancelled. Cancelled. Fresh tender floated, wherein we participated. His wife's firm also participated. But since her contractor registration was cancelled, this tender also goes. Now, my Lord, may come to Gordon Das Bhanji, Commissioner of Police. My Lord, it's a celebrated old case. My Lord, may come to para 14. This is 1952 SC, page 16. My Lord, may come to para 14.
1952.
AR 1952, Supreme Court, page 16. At the top, Lordship will find the small one, my lord.
Oh, yes, this one.
The small one, no, that's MS Gill, my lord. The other one, the small one. Commissioner of Police Bombay versus Gordon Das Bhanji.
Commissioner of Police.
My lord may come to para 14. An attempt was made, Lordship finds it, was made by referring to the commissioner's affidavit to show that this was really an order of cancellation made by him and that order was his order and not that of the government. We are clear that public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. What I am here on, my lord, is that the records have to show on what date, from where they got all these documents, have to show that we were actually non-responsive, not by way of a mere affidavit. Now, my lord may come to.
The respondents are represented.
Yes, my lord.
Are representing all. Otherwise, it's unnecessary.
My lord.
Respondent number 4.
Only. Others?
Others, Lordship, it will cover because the executing agency is the respondent number 4, Lordship.
My lord, 1 and 2, my lord. 1 and 2 is the department, 2 is the chief engineer. They are important, my lord. And 5, my learned senior friend is.
One is also important.
Important, my lord.
None
1, 2, they
appears-
have to be
None
there.
appears today. You are representing only 4.
Affidavit have been filed only on behalf of number 4 only, Lordship.
Affidavit file.
Yes, on behalf of 4.
4.
Yeah,
Is
I
the
am representing 1,
executing
2,
Eh,
authority,
3,
executive engineer.
4.
Yes, my lord.
Who is representing 1, 2, 3?
Lordship, I am representing all, but affidavit have been filed on behalf of respondent number 4.
And 5?
My learned senior.
Oh, you are.
But my lord, whether as to on the what basis, my lord, the contractual registration was cancelled, that the chief engineer has to explain, my lord. Number 2.
Actually required.
Yes, my lord. He has not filed any affidavit.
His affidavit is needed. Respond number 2 is a chief engineer. No?
Chief engineer.
Is a issue. Executive man.
As the cancellation order amalgamation.
Approval was given. No?
Yes, my lord. So he is an important party here.
He is simply the executing authority, executive engineer. Ask him to file affidavit. Unnecessary. The council. He's the government advocate.
God. Oh, my lord, he may represent. My learned friend may represent, my lord.
Represent.
My lord, he is representing standing council. He will have to file.
Learn a senior counsel. Hey, he says that a affidavit of chief engineer is necessary.
That is a part of the.
Just I am informing you.
Part of the.
Informing you verbally.
Here I am being implicated as a response number 5. But I'm a MLA, sitting local MLA objective. The inviting of tender, that is the functioning of the executive engineer, functioning of the department. I have no involvement at all here in that case.
The petitioner is suspecting. In fact,
I'm convinced, my lord.
Without any document.
Let me as a responsible part only on suspicion. They have not shown even a single letter written by the MLA to cancel the tender.
An opportunity may be given to them for.
Your name, please.
Lordship, in our affidavit, we have stated
No, the respondent number 2's affidavit is required. He is a chief engineer, no, of the department. He is just an executive engineer. Respondent number 4 is an executing authority only. Although he was involved in the decision-making process. That is there, of course. But with the prior approval of this chief engineer, these things were done.
In fact, the cancellation was made by the chief engineer. So his.
Hard so and so. And Mr. Muk Patin, learned senior counsel, appearing for the respondent number 5. In course of hearing of the matter, it appears this court finds it expedient to ask the respondent number 2 to file an affidavit in opposition if so advised, verifying the entire position of the matter, leading to cancellation of the NITs.
Previous NITs.
Yes.
NITs. The interim order.
Interim order to continue. As released up in the second week.
Well, could it be on 17 November, my lord, if it is not inconvenient?
17/11. As you were representing, you ensured. You will ensure that the affidavit as required is filed without seeking for further adjournment. On 17/11.
17. The interim is continued.
Interim continues.
Deeply obliged.
That's good, yeah, no? Yeah, admission. Again.
Well, this is a medical medical reimbursement matter, my lord. My lord, my mother was suffering from cancer. My mother was suffering from cancer, my lord. I'm a government servant, my lord. So initially, my lord, my father he was an IAS officer, my lord. My mother was under his care. The reimbursement of her medical bills were made on account of my father, my lord. The initial approval, my lord, for the treatment, my lord, because earlier he was in the government of Goa, my lord, and the government of Goa, my lord, had approved. Thereafter, my lord, when he was transferred to Arunachal Pradesh, my lord, if my lord may come to my affidavit filed on 31st of March 23, my lord, a small affidavit, 31st March 23. Or my lord, I'll simply read out, my lord, this was on 24 June 2015, the initial approval given by the government of Arunachal Pradesh for her treatment.
Your affidavit.
There are many affidavits, my lord. An affidavit filed on 31st March 23, my lord.
35, so here's our. Well,
the last page of this, my lord, page
by petitioner.
Additional
affidavit.
Additional affidavit. Page 4, my lord, annexure R1. My lord, will see the date 24/6/2015.
Relevant para.
My lord, approval is accorded to the consultation and treatment of Srimati Hage Yangung, wife of my father, my lord.
Para number 2.
Para 2, yes, my lord. Para 2, that is the, my lord, deponent begs to bring on record the initial.
Approval granted by the respondent number 6, Director of Health Services, Government of Arunachal Pradesh for treatment of the petitioner murder. All right.
At Rajiv Gandhi, my lord, this document, my lord, is at page 4.
Approval is hereby accorded for consultation and treatment of Gandhi Hospital, myself.
Rajiv Gandhi Hospital, my lord, at Delhi. My lord, thereafter, my lord.
What is your prayer here?
My lord, the
You were given permission for treatment of your mother.
My lord.
Then you submitted the final
Bills.
bill supported by
Documents,
documents.
certificates and all.
Then now
They have refused, my lord.
why?
My lord, they say that because of the coming into force of the Arunachal Pradesh Universal Chief Minister's Universal Health Scheme, I am not entitled to. And in fact, that is also not clear.
When the approval was given,
Initially 2015, then my lord, my approval, renewal approval, my lord may come to page 21 of the writ petition, my lord.
approval was given
Sorry, my lord.
on the date of this order.
My lord.
Whether that scheme was available
No,
in force.
No, not in force, my lord. It is the Central Medical Attendance Rules which apply, my lord, 1944. My lord, the approval given to me, my lord, at page 23 of the writ petition. This is not a fresh approval. My lord will see the first word. Renewal approval. This is in continuation.
Revised estimate.
Yes, is
Page number 23.
23 of the writ petition, my lord.
Oh, 23.
Annexure 3, my lord.
Page number 23.
Annexure 3, my lord. My lord, renewal approval is hereby accorded for consultation and treatment of Srimati Hage Yangung. Treatment approval is at Rajiv Gandhi Cancer Institute and Research Center, so and so, my lord. 1 year validity from the date of issue. My lord, my mother was treated there. She died, my lord. She died, my lord, in October 2018. Now, I had submitted the bills. They say that because of the APCMUHIS, Arunachal Pradesh Chief Minister's Universal Health Insurance Scheme, my lord may come to page 30, the impugned communication at page 35 of the writ petition, my lord.
Page number?
Page number 35 of the writ petition, Annexure 8, my lord. With reference to your medical reimbursement bill dated so and so and subject, it is regret to inform you that your mother's medical expenses amounting to rupees 33 lakh and odd could not be materialized for pass and payment owing to implementation of APCMUHIS/CMAAY. These are two different schemes. Initially, it was APCMUHIS and thereafter from 2018 CMAAY, Chief Minister's Arogya Arunachal Yojana. They are even not clear under which, because of which application of which scheme it has been rejected. They say either or. They are not clear. Now, my lord may come to this Arunachal Pradesh Universal Health Scheme. This is, my lord, from page 38. I have extracted. I have put in the scheme.
Arunachal Pradesh.
Arunachal Pradesh Chief Minister's Universal Health Insurance Scheme.
Where is that?
My lord, from page 38, my lord.
38. This is the order.
That is the scheme, my lord. Has decided to
Annexure
launch.
10, na?
Annexure 10, my lord. That is the scheme. My lord may come to
Launch the Arunachal Pradesh Chief Minister. This was of 6/11/2013.
13, but it was intimated in 3/11/2015. I have some other judgments on this. 3/11, my lord, 3rd November 2015. Communicated.
And
2015. But prior to that date, the approval was granted and my mother was already under treatment from 2013 onwards. Now, my lord may come to page 40 of this particular scheme. The first line, my lord. Yes, my lord. And their dependents will presently not be beneficiaries under this scheme. It is not applicable to government employees. So how can they say, my lord, that because of the implementation of this scheme, from 3/11/2015, I will not get, my lord. I got my mother got the reimbursement till my father's retirement in 2017. After that, he has not got. But because of this, my lord, this is not applicable at all. Since this is not applicable, my lord, I am covered by the central medical attendance rules that I have put in by way of an affidavit. The treatment was ongoing from 2013. It is, though there are many affidavits exchanged because there was some confusion between the departments. And my lord, their own document, they have filed an affidavit recently, my lord, last week. Which date did you file? 4th of August is the date of the affidavit.
That state health insurance scheme came into effect from 2015.
15, 3/11.
But these documents were of earlier period.
Well, there is another
She
document.
was cancer patient.
Cancer patient. She died, my lord, because of cancer in the hospital itself.
2018.
18. My lord may come to another document, my lord. This is also relevant. In the affidavit filed, my lord, last week, sworn on 4th of, my lord, 4th of August. 4th August.
Who filed?
My lord, by Tapi Loma. Respondent number 4.
Respondent number
4. Tapi Loma. Additional affidavit.
Then you are filed by.
This is August or October?
October.
October.
All right.
4th October. My lord may come to page 6 and office memorandum dated 9 January 2017.
Page number
6 of this affidavit.
4th October, na?
Yes, my lord, 4th October, but it was typed as August. So most probably typographical error, my lord. Page 6 of this affidavit. Last
How
week.
many affidavits are filed? By
So
respondent
many, my
number
lord.
4? Let's see. 4, 5.
Issue is small.
This is 28 February 2023 by respondent number 4.
My lord. My lord, this document, my lord, is 9th January 2017 in this affidavit. The last affidavit. Last affidavit filed. Last week.
Respondent 6 and 7.
That is another one, my lord. This is of respondent number 4. It will be together, my lord, with that. Because both were filed last week. Of Tapi Loma, my lord. My lord, finds it. My lord finds it. Tapi Loma. Santos.
Tapi Loma.
Is the deponent of the affidavit, my.
Date 28 February 2023.
My lord may see my copy then, my lord. This was my. So
This is 26 August.
not 26. This is Econ mid-side one.
This is 11 November.
2020, last week, my lord.
4 affidavits are filed.
My lord. No, more than 4, my lord.
More than 4.
My lord, my colleague had taken out a list. These are the affidavits filed.
How many?
My lord, 10.
10 affidavits
10
are filed.
minus the writ petition. So 9 affidavits.
9.
My lord may see that document.
Hmm.
This is of January 2017. Last week. My lord may come to page 6. 9 January 2017. It is observed that some departments have submitted individuals cases for additional allocation of fund in connection with medical advance, medical reimbursement of medical treatment expense, even after implementation of the Arunachal Pradesh Chief Minister Universal Health Scheme. After implementation of the APCM UHIS, there is no fund provision for medical advance reimbursement. As such, all departments are again requested to advance their staff to avail benefits of APCM UHIS instead of recommending for medical advance reimbursement. Next para is important, my lord. Further, it is to inform that medical treatment cases which are not covered under existing guidelines of APCM UHIS is under examination in Health and Family Welfare Department and it shall be restructured. Such cases may kindly be retained till revised guidelines are issued. So my
Has to wait.
they have to wait. But my lord, my case, my lord, is of 2013. And the
This is this was dated 9
17.
January 2017.
17. Now
Till
6 years.
today, what is the revised guidelines? Guideline in this regard? Revised guidelines are issued or not?
My lord, till then, my lord, there's no instruction regarding the risk.
Now, as on today,
My lord, I'm not.
except the
instructed,
scheme.
My lord, except the scheme, this regarding revised guideline, man. That is not yet notified and I have not.
Now, see, otherwise this will be incomplete, you know.
Yes, man.
My lord, in
What
fact-
are the revised guidelines now?
My lord, in this regard, my lord, we require to take instruction because as of now, I have no instruction this.
Yeah,
this
the matter has been delayed now.
My lord, that I appreciate, my lord. Now, what happened, my lord, they are, although the scheme, my lord, universal scheme, chief minister universal.
That
scheme,
is
although-
different.
Yeah, my lord,
It was filed long ago
my lord,
when this new scheme had come into force.
my lord,
But the existing bills pending on that day,
my lord.
what would happen?
That will take, they will take.
For this
appropriate
task
decision.
will may kindly retain till revised guidelines.
Yeah. They will take appropriate decision, my lord. That decision has not yet out.
Now you obtain instruction.
My lord,
But
my lord,
I'll take instruction on this aspect.
my lord, in this case,
Again, number 10, let me repeat.
My lord.
my lord, in this case, lordship was pleased to pass an order, my lord, in a similar case, my lord, directing them, my lord, this is of this on the bench only, my lord.
New situation.
My lord, no, but,
This
my lord,
indirectly,
my lord, this,
nothing has been publicized.
they have not done anything.
2017.
My
New
lord,
guidelines
6 years,
have, issued.
6 years have gone by, my lord.
Hmm.
My lord, this is a order of, my lord, 30th January this year, my lord, of this on bench, my lord, wherein we were directed to be paid as per the existing guidelines.
Now, all right, let them obtain the instruction then,
My lord,
Yes, sir.
because this document is there, no?
my lord.
It was earlier produced or not?
This, they have filed last week only, my lord.
Huh?
They have filed last week.
This is document of 2017.
My lord, this is filed by the finance department, my lord. The last.
All
week.
right,
I'll take
but that
instruction.
may be, but
My
with injustice has been done.
Yes.
Huge amount.
My lord, yes.
He is an employee of
My lord.
which department?
The culture department. I'm a language officer, my lord.
Language officer.
And my lord, it's a genuine case. Because my mother died, the death certificate is
Is
of
there
the
any
hospital.
other ground that the documents, be the medical documents were fake,
No,
etc., etc.? There is no such
No.
plea.
My
that
lord.
is not.
Simply due to introduction, launching of the new scheme.
My
It
lord.
is held up.
My lord, that is what happened, my lord. Here, although in the scheme, it is said that the government, regular government employee may not cover up. But the fact of the matter, my lord, although it is stated, but the government employees are getting avail of this scheme, my lord. Now they have even they stated in their affidavit also, the finance department, although it is there, but overriding that guideline, my lord, they are providing these facilities under scheme to the regular government employees. What they have specifically stated in their affidavit also.
You obtain this instruction file affidavit
My lord,
on this. He revised guidelines.
my lord.
If not produced, then order will be passed.
My lord, as per.
No, it cannot
I'll
be
take-
dragged, no?
Yes, you're right.
Or Mr. Give the name of others. In course of hearing of this matter, it is, your standing council
Health department.
So, standing council health department has produced an office memorandum.
My lord, this is that office memorandum produced by the
Finance department.
finance department.
Finance department, can see.
We are also surprised.
9/1/2017. Wherein it is stated that the medical treatment cases which are not covered under the existing guidelines of the APCMUSIS. It shall be restructured and revised guidelines would be issued. However, the learned government advocate, junior government advocate,
Yes, Your Lordship.
junior government advocate, submits that she has to obtain instructions regarding these revised guidelines. If issued by the government after the aforesaid OM dated 9/1/2017 was published. What is not happening? Madam? What is not happening here?
First-
See, 2017, then the matter is kept pending.
6 years, my lord.
Now it is 2023.
Almost 7 years, my lord, now, January 2017. Well, that may also be reflected.
Pending which? No, because there is no confirmation. No?
Yes.
Yes, Your Lord.
My lord.
In view of above, the learned junior government, health department, finance department.
It's the finance department, representing
Finance
finance
department. Response number?
No.
Response number 4.
Yes, Your Lordship.
Again 4. Again 4. Response number 4 shall file an additional affidavit. In this regard, enclosing therewith the revised guidelines if so issued.
May I take the
This will publish.
published?
Published will also be difficult.
Published,
If not published.
my lord. Then they have no effect, my lord.
Likelihood, no?
My lord, MR Mondal. MR Mondal says,
Mondal's case.
my lord. My lord, could I take back
Is
my,
the 3rd week of November?
17 November? my lord?
17, okay. 17.
Deeply obliged. My lord, could I take back my copy, my lord, of the affidavit? Could I take back my copy of the affidavit, my lord?
Copy of affidavit, somewhere like it.
My lord, this is a land acquisition matter, my lord. The land was acquired without publishing any award, my lord. Under the,
Okay.
no award was published. My lord, the DC was supposed to file an affidavit, my lord. My
DC, Deputy Commissioner.
Deputy Commissioner, he is the
You are
most.
specific whom?
I am for the land management department.
You are land for land.
They have filed,
management.
yes.
DC
I have
acquired the
filed.
land.
Yes.
Well, this is some more time will be given, Your Lordship.
Affidavit filed.
No, for filing counter affidavit for Deputy Commissioner, Your Lordship.
Counter affidavit not yet filed. Today filed.
Not filed.
Oh, counter affidavit on behalf of respondents number 8 and 9.
8 and 9, my lord.
8 and 9 not filed. The affidavit, counter affidavit shall be filed within 4 weeks.
My lord, 17 November.
Within 4 weeks, this is the matter on 17.
Oh, my lord.
17, 11.
My lord. Deeply obliged.
This is a matter which will take some time, my lord. You have all agreed. If it is, this is likely to take at least 2 hours. Now, to make
all right,
it,
then.
my lord, I have had a word with my learned friend. So we have agreed on, my lord, 14th of November.
So in other matter, your other matter is
My other matter is fixed on 20th, but on 20th, apparently there is some problem. Your lordship, I fix it on 14th.
14.
We have
In fact, it was listed today for the final hearing, so we were ready. I'm ready, also ready.
And I'm
On 14th,
representing the
10
respondent
minutes.
number 4.
Yes, yes, yes.
I'm representing respondent number 4.
I'm for this statement.
Done. On 14/11. On request.
For a final disposal, madam, let me mention.
That is all, that observation is already there.
He already admitted, no?
No, this is for admission.
Yeah, admitted.
Yes, my lord.
Admitted. This for hearing on 14/11.
My lord, before admission, there is an order that the maintainability, issue of maintainability will be taken at the first instance. So
That is why
without-
this for
All
admission.
right,
Your lordship
yeah,
has fixed it for admission only. Because
for
maintainability-
admission hearing.
That-
That maintainability
issue, that is an order passed on 9/6.
on a prayer of permit for the bond.
9/6.
On 9th of June.
There is an order.
Okay, for admission hearing.
Oh, no, no. issue. No issue.
This is last thing. Last second. It's 19 and 20.
Yes, Lordship, 19 and 20. Lordship,
Yeah, IA, no?
yeah. IA 168. Lordship, this is just for implement of respondent number 5 and 6. That is veterinary department. Director.
Veterinary department.
Yeah,
What do
veterinary.
you say? Is there any objection
We have to.
for implement?
No.
Okay, implement it. This is regarding what? Regarding?
Lordship, this is regarding the LPC.
Impede the Department of Animal Husbandry, Veterinary and Dairy Development, Government of Arunachal Pradesh, a respondent numbers 5 and 6.
Yes.
Department, Animal Husbandry and Veterinary, and respectively. 5 and 6 respectively in the connected WPC number 413 of 2022. That's right. Okay. Who will insert?
Lordship,
Who will insert? Registry or yourself?
registry. No
Registry.
registry. Let's go for registry.
Shall do the needful for implement. Yes, very good. 5 and 6.
Master.
This in the third week of November.
Yes, sir.
Master.
Yes, sir.
May it be also, my lord. My lord, as per the, my lord, our argument on the last occasion. My lord,
Last occasion means on Friday.
yes, sir.
Ah.
So, my lord, I would like to submit some decided cases of our own High Court in this case, my lord.
Can it be completed?
So this
today?
is, my lord,
Yes, of course. In fact, Lordship, we have in fact argued all the points. London Standing Council for the Department of Education has argued. And
Some citations are there.
yes, my lord.
You cite those judgments. Jammu, I heard. You will also heard. Yes. Termination petition along with others appointed in grade 4.
My lord, there is a condition as per the appointment order, my lord, that I have already referred, my lord. The annexure 2, page 28 to 30. Monitoring period and annexure 2, page 28.
28.
28.
Twenty-eight, she
yeah.
was grade A. 27 and 28. 28. Miss Saru Loang is hereby appointed upper division clerk.
Yes.
Huh?
Then condition number one, bracket A, small
The
f.
appointment is purely temporary
Yeah.
and may be terminated at any time without assigning any reason after serving 1 month's notice. Also, all right. You refer to this clause on the last occasion.
Yes. So this is very important and it covers my case also.
How it is interpreted then? Is it such condition is interpreted here?
Yes, yeah, number one is that the appointment is purely temporary and may be terminated at any time without assigning any reason after,
After
serving,
serving 1 month's notice.
1 month. This is very mandatory.
1 month's notice.
Mandatory. Then, if he/she wants to
You will
join,
give notice or not?
no
No.
notice. No notice. Secondly, my lord, I also referring, my lord,
It's
the
28.
refer the affidavit.
28.
Affidavit filed by the my lord respondent authorities, which is very important, my lord. It is their own document. The committee was constituted under the
What is
chairmanship of
the relevant paragraph here?
my lord, relevant paragraph is my lord.
Paragraph 14. Paragraph
Here,
14.
my lord, if the, as per the terms and conditions,
Paragraph 14, you see, considering the submission of the learned senior counsel appearing for the petition, as well as the ratio laid down by the Honorable Apex Court in the cases discussed over this copies of the considered view. The terms and conditions mentioned in the said offer letter 14/1992 are binding to both the parties.
exactly, my lord.
This is the principle. Manipur. In the fact we discussed above, it is admitted fact that the services of the petitioner had been terminated without giving 1 month's notice, nor 1 month's salary for the notice period. Therefore, unavoidable inference.
So here, secondly, my lord, it is their own affidavit, my lord. And next, page number 40, my lord, of the government affidavit. Affidavit in opposition filed by the official respondent number 2, 3, 4, and 5.
2, 3, 4, and 4 and 6.
5, my lord.
5 or 6?
5. 2, 3, 4, and 5. So here, my lord, they have constituted committee, my lord. And that committee was chaired by Ganya Laji, Secretary Education, my lord, which is totally wrong. And this is totally misleading. And this is on this account only, my lord, the impugned appointment order given to the respondent number 7 is liable to be set aside in court, my lord. And thirdly, my lord, I have referred the my lord, some notification regarding the reservation policies, my lord. When the respondent number 7 was appointed to the post of upper division clerk directly, why they have not conducted the interview or written test? And this appointment has been done after lapse of 3 years. On compassionate ground, when the appointment order should be made
within a period of 1 year.
Hmm.
1 year, and the petitioner should be either that son or daughter or any person related to the deceased person. Whereas the respondent number 7 is not related to any person, my lord. R.K. Gupta. So in view of this, my lord, this is a fifth case whereby your lordship may be pleased to set aside and quash the order purportedly and most illegally issued by the respondent authorities. That's my submission, my lord.
Well, I think small clarification is required here, my lord.
Yes.
My lord, the terms and condition of her appointment, condition number 1, my lord, it says if we terminate her contractual appointment, my lord, before expiry of the contractual period, my lord, notice is required, my lord. When the contractual period has naturally expired, my lord, then where is the question of this serving any so-called notice, my lord? It is expired, my lord. It has already expired. After 28, my lord, after page number 28, as I have submitted in the last occasion also, my lord. After page number 28, 1 year expired. Thereafter, we extended.
You did not renew.
Yes, we didn't renew, my lord. Then when it is not renewed, there is no question of this giving notice to her, my lord.
Sorry for interruption, my lord. The condition of the appointment order speaks the truth.
No, it was, she was appointed for 1 year.
Yeah.
After 1 year, on completion of 1 year, the tenure was not extended.
Yes, ma'am.
That is his stand.
No, man, I object to this because there is a series of order, my lord. Series of order, my lord.
Series of order, my lord. We
Annexure.
we have shown your lordship one extension paper, 6 months, my lord. 6 months. And her case is not that. We have not allowed her to complete her this contractual period, my lord. We allowed her to complete, my lord. After allowing her, after completion of her this contractual period, my lord, I think there cannot be any further notice, my lord. It expired naturally. And regarding, my lord, compassionate ground, my lord, with utmost respect, my lord, compassionate appointment, my learned senior seems to be in the understanding that only R.K. Gupta, this private respondent should be a relative of R.K. Gupta. It appears to be his understanding, my lord. My lord, it is not the thing, my lord. R.K. Gupta's post should be given only to his sons and daughters, my lord. His heirs, no, it cannot be. It is a public post, my lord, not hereditary. Government posts are not hereditary, my lord. This appointment, this appointee, private respondent, is a heir of our one expired employee, my lord. So we can place her in any befitting place, my lord. It is not that only in R.K. Gupta's place, only his heir or some kid and kin should be placed there. No, it is not hereditary post, my lord. If such argument is accepted, my lord, all our government vacancies will be converted into hereditary post, my lord. That cannot be accepted, my lord. This man was qualified. He also lost his parent in this harness in duty, my lord, in our department. That's why he has been appointed in place of in the vacancy arose from the retirement of Mr. R.K. Gupta, my lord. That is the ground, my lord. So we should not interpret such compassionate appointment in that narrow way, my lord, like hereditary. Post cannot be hereditary, my lord. Regarding my lord, page number 40, Secretary Education, my lord. We have this verified it, my lord. It is a typological mistake, my lord. Page number 40. My lord, Gania Lage, Secretary Education. It is a typological mistake, my lord.
What is that?
Well, and page
Page
40
number-
of
Page
the
40,
page 40
page
of
40,
the
my lord.
affidavit.
40,
Page 40 of my affidavit, my lord.
affidavit of,
Affidavit in opposition,
Government.
government 2346.
2, 3, 4 and 6.
6, my lord. This is a typological error, my lord. We have verified it,
2, 3, 4 and 6.
my lord. Page number 40.
Wait.
Learned senior is harping on this, attempting to make it frivolous and something like. It is not fabricated, my lord. The record is very much in the office.
2, 2, 5. All right. Page number
40, my lord.
14.
40,
40.
40, my lord.
Where is 40?
And
Page
in
40,
the
my lord.
affidavit filed by the respondent number 2, 3, 4, and 5.
My lord, page 1, page 40, my lord.
40.
Yes, my lord.
Order
Order, my lord. Yes.
Hmm.
Order 8 January 2018, my lord.
in pursuance to the government.
My lord. He says, my lord, below SD, the one who approved this, my lord, Gania Lage, Secretary Education, Government Arunachal Pradesh. My lord, of course, he was not Secretary Education. That has been clear in group number 1, my lord. Above, serial number 1. Gania Lage, Director, Secondary Education, my lord. That has been.
He is secretary.
No. He is director, my lord. He was director at that point of time, but secretary in place of being secretary, director, secondary education. My lord.
Director of secondary.
Yes, my lord. He was.
Secondary education.
Yes, my lord.
That means
There is no
Or
question.
wrongly typed as secretary.
Yes, has been inadvertently typed as
No,
secretary.
there is a
my lord.
fraudulent activities undergoing there.
My lord, for that.
There is a fraudulent.
For that, my lord, if it is fraudulent, FIR is required, my lord. He may file FIR, my lord.
If so, then you should have filed an affidavit in
How to get
additional
this
affidavit.
committed?
That cannot be.
He who is the director,
My lord, my lord.
but issued as secretary.
Secretary.
Education.
No, my lord, actually, it has been informed to us, it is typological, my lord. Typological mistake, my lord. Only Secretary Education is wrongly inserted, my lord.
This
This
is
Tommy
not possible to
Doke,
correct.
JDSE, DDSE, he has signed it, my lord.
Very serious lapse.
And regarding, my lord, that one more notice, my lord.
Director, who is director, who is secretary? His sign is secretary. You see.
No, my
very
lord.
serious matter.
My lord, it sometimes happened, my lord.
No.
It sometimes happened inadvertently.
No, this cannot be taken it lightly.
My lord.
It cannot be taken so lightly.
Dismissed from service.
My lord, in serial number 1, actually, his designation has been clearly shown, my lord.
Gania Lace.
Yes. Director, secondary, serial number 1.
Is chairman.
Yes, my lord. Clearly shown this name. There is no question of this fraudulence here, my lord.
Yes, you have not filed any additional affidavit or any counter.
Regarding, my lord, regarding one more notice, my lord. There is no place for serving here notice, my lord, because service is necessarily in that, my lord. After ending of the contractual service, my lord, we cannot.
You just discontinue.
Yes, naturally it dies.
Please ask me.
Okay. I will summarize. My lord, I will just summarize. Every point has been, in effect, placed before your lordship. Lordship has seen in the earlier occasion, last Friday, when my friend for the Education Department has advanced his argument. He has pointed out that the Sarul Lawang, who is the petitioner here, she was appointed by incompetent person. As you Lordship may remember, this post was meant for the secondary education. And the appointment
That
of the
was
yes,
bifurcated, no?
yes, that was
It was
bifurcated.
He
And-
said that.
Yes, Lordship.
You also said.
Yes, Lordship. That-
Friday.
Just I would like to highlight the fact, Lordship,
Ah.
because they only,
Reminding-
yes. Petitioner, she was appointed by the Director Elementary Education. And your Lordship has seen that this post.
Secondary.
Yeah, no, petitioner was appointed by Director Elementary Education. And this post, in fact, it belongs to secondary education. Even R.K. Gupta, who was retired from the service, he still draws his pension from secondary education, not from elementary education. So this, first of all, Lordship kindly appreciate, this post is meant for secondary education. Somehow, erroneously, Director Elementary Education has appointed, given her the contractual appointment. That too, Lordship, it was only for 1 year. My friend has directly submitted, Lordship. What I could gather from this appointment order, if in the case, before the expiry of 1 year contractual period, if she is terminated, then only this 1 month notice is required. But your Lordship has seen, she has served for 1 year, and thereafter her service was extended. Lordship, may kindly come to page number 35. 35 is her extension order. Last extension order. Page number 35 of the writ petition. In my petition, it is 35, 36. 35 is also the 36 is also the loss.
Is the extension order?
Yes, it's extension order, Lordship. Page number 33, Lordship. In fact, here in my
33.
yes, in my petition, which has been served to me, it is 37. But I will report 33 only, Lordship. Page number 33, and except for series. It says, Lordship, may I read, Lordship? Approval is hereby accorded for extension of service of Miss Charu Lawang, UDC contract in the office of DDC Konsa,
Will automatically be cancelled.
District Tira for a further period of 6 months, with effect from 31 January 2019. Lordship, here the last day of his service is her service is also given to 31st July 2019. Lordship, has seen this order is not under challenge. By this order, Lordship, the requirement of serving prior notice of 1 month goes, Lordship. She had gladfully accepted this appointment order, where it does not provide for serving of 1 month prior notice. She had gladfully accepted and served the department and took whatever the punishable benefit she was supposed to get. Now, of late, she cannot say that otherwise he ought to have imputed this order also, Lordship. Because this order does not contain this requirement of serving notice of 1 month. So she has enjoyed the extension period of 6 months without agitating that no, this order should contain the same condition as provided in the earlier initial appointment. So since she did not challenge this order, now she cannot say that I ought to have been served prior notice of 1 month. That is, to me, to my understanding, that is. And this 6 months, of course, she served. And Lordship, See the difference. I had Lordship argued. Firstly, the first belonged to secondary school. She was erroneously somehow given contractual appointment by an incompetent person. That is Director Elementary Education. Lordship has also seen R.K. Gupta. He had retired from secondary school. And now also he's receiving his pension from the secondary director of secondary. Now, thirdly, Lordship, she and me, the respondent number 7, are in different footing. We are not from same class. She is not claiming the first on the ground of on this compassionate ground. I have been given appointment on compassionate ground, and rest the submission, Lordship, I will consider with the submission advanced by Standing Council for the department. And I see, Lordship, there is no ground to allow this writ petition, and it should go, Lordship. That is my humble submission, Lordship. I should not be disturbed because my parent has served the department for long period. After his demise, seeing our condition, the authority, of course, by conducting DPC, it is not a backdoor entry, Lordship. DPC was conducted. My name was recommended. So therefore, there is no procedural lapse also in appointing me. So, Lordship, my humble prayer is that this writ petition should not be allowed, rather it should be dismissed, because it's a writ petition filed by an incompetent person, in fact, who is not in the same footing as the private respondent number 7 is. That is all my submission of lies.
May it please, my lord, I'll have to take your lordship, my lord, regarding the scheme of the compassionate ground, my lord. Always said by the our own High Court, my lord. My lord, at any rate, my lord, the selection procedure conducted by the board is totally illegal.
Always we look into.